I call the Labor Committee to order for public hearings on Senate Bills 28, 67, 169, and 171. For committee members and members, just a couple of notes. You just got out of the leadership meeting across the hall. And we're going to start getting House bills amended by the Senate. When those come back, we have the option to concur, non-concur, or not concur with a committee of conference. Those are our three options. And Representative Sullivan and I we'll take a look at those and figure out where we want to go on those in terms of a response for the committee. If you concur or not concur, then we just speak to that at the floor, and then we'll vote on it as a House. But if it's a non-concur with a committee of conference, then there'll be four members designated from the committee to represent us at the committee of conference, and we'll designate who those people are, and then go forward based on whatever the amendment is or the disagreement is with the Senate. And so that's going to start pretty quick here. Now, the good thing is we only have one bill right now over at the Senate. The hearing for that is tomorrow at 1 p.m., 1300. Yeah, I know Jack will represent us at 1 a.m. because he won't be asleep anyway. For reference, there's 189 bills coming back, of which we've got four, and we'll hear those and listen to those today. So we'll be done with our Senate bills as of today. No session next week on the 17th, but plan on session on both the 24th of April and the 1st of May. Not on the 17th. That's official as of 10 minutes ago. So that's, for me, that's good news, so I don't have to drive back from New York. Just in general, and we are not guilty of this, but just as you do your committee reports, if it's with an amendment, then your first sentence of your committee report has to address the amendment. HB 200 as amended. The amendment says fix these three words. The bill says this, and then you move on. And the idea is, in the House, the first thing you vote on is the amendment. And so the thought is that the committee report needs to address the amendment so that people, as they're preparing, understand what the amendment is saying. The 29th is the last day. It's not really pertinent to us in the committee, but it is in terms of full house sessions. There'll be bills, throughout that we'll have to go to full house session for. The other thing is that reflects all of us is that they are clearing this building out on the 22nd of May. And so if you have papers, coats, jackets, coffee pots, you name it, in this building, they're clearing it out. And the next year, we will be working out of another facility. It'll be tighter, smaller, but they're renovating, they're gutting this whole building, redoing it, and it's going to take almost 2 years. Yes, sir.
Thank you, Mr. Chair. Wondering if the keys for the lockers, should they be returned to you or to the clerk or what?
I would return them to Jamie.
Who's Jamie?
She's our assistant.
Oh, right. Thank you.
Okay, if you leave it to me, know yourself, know your enemy. If you're giving it to me, it's going to be a long shot. But if you give it to Jamie, I'm sure it'll happen exactly correctly. Okay?
Thank you.
Thank you. Good point. Are there any questions or comments before we proceed? I just wanted to make sure you guys knew sort of what's going on. And so was this movement of this building, the LOB, is that a surprise to anyone?
No.
Okay. Okay. All right. So first thing I'd like to do is open the hearing on SB 28 relative to workers' compensation claims involving. Sir, I would love for you to lead us in the Pledge of Allegiance.
United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. So Senate Bill 28 relative to workers' compensation claims involving emergency responders with acute stress disorder or post-traumatic stress disorder. And Senator Burnsall, you're all set to go. Thank you, ma'am.
I am.
Over to you.
Thank you. For the record, my name is Regina Birdsell, State Senator for District 19, which encompasses the towns of Derry, Hampstead, and Windham. And I'm here as the prime sponsor of Senate Bill 28. Basically, this bill provides that the date of injury for purposes of workers' comp claims by our emergency responders with acute stress disorder or post-traumatic stress disorder shall be determined in accordance with the statute governing date of injury and for occupational disease. What that typically means is, in the case of a first responder, sometimes if they've had a 20-year career, they've suffered PTSD, they may not have known it, but over that 20-year period, they've had numerous occasions to suffer or witness things that they shouldn't have to. And finally, at their, let's say their 15-year or their 20-year career, they finally experience another one and they seek treatment for it. So that the workers' comp claim will be from the date that they either ask for help or they claim an injury. So that's basically what this does. Because sometimes PTSD doesn't show up for a number of years, and there will be a traumatic event that triggers it, and that will be the event that the workers' comp claim will use as a date of injury. And I'll entertain it.
Are there any questions? Representative Flanagan.
Thank you, Chair, and it's nice to see you, Senator. It's been a while. It all refers back to the last sentence that the changes, that is under RSA 281A16. And so I tried to research it before, but I couldn't pull it up on my phone. So it basically is, does the date of injury from the moment they complain about the issue, or is it to go back to other stressful occurrences that could have been accumulated to that point?
It's for instance, if you had a 20-year career
Right.
and you had your last encounter and it hit home
Right.
and you asked for treatment, that would be the date of injury.
Okay.
If, let's say, 15 years into it of a 20-year career, and then you realize you experienced something at 15 years and you don't, you realize at 20 years that you are suffering from PTSD from that experience, it's the date of treatment.
So it doesn't go back to the 15 years, it goes back to the point in time where they asked for treatment. Okay.
But PTSD, as I'm chair of the PTSD Commission, PTSD is an accumulative type
Of
of
course.
offense.
Right. Don't we all have such stresses in our life?
Yes. Not quite like they do, though.
Yeah.
Yes, ma'am.
Thank you. Thank you for taking my question, Senator. What happens now? So if this were not to pass, what is the current way that this is handled, and how does this change it? Thank you.
I'll answer what I think is the case, and we have some people behind me that will, if I'm wrong, they'll correct me. What happens right now is you can't go back 20 years. If you experience something, let's say in your first year of being a first responder, and right now you realize that you need help from what happened 20 years ago, we can't go back that far.
Okay, ma'am, I just want to make sure I'm clear on this. And I do have more than a little experience with this. As it's a cumulative event, according to the way this is written, if I come in and I say I've got 30 years in the Army, but when I was a lieutenant 28 years ago, something happened, and I say that caused a PTSD, it wouldn't apply unless I had actually asked for assistance or been treated in some way to document
For
that
work-
occurred.
For workers' comp only.
Right.
Yep.
Okay. So it has to be documented. It's not just my recollection of something that may or may not have happened.
Well, it would be the first time you either ask for treatment
Okay.
or the last episode, if it was recent, the last episode you had with PTSD.
Okay. But how is that last episode documented? Because I could just claim, when I was a second lieutenant 28 years ago, this happened.
Well, we do a date of injury. So when they come back, and they can explain, the people behind me can explain a little bit better. When they come back, there's usually, if it's been a traumatic event, like the burning of a house, a child has passed away, then they do have a peer organization. And if someone feels that they have experienced PTSD, they will do, and they acknowledge it, they will do a date of injury form for workers' comp, and then things move forward.
Okay. But that's a documented date of injury form that you can then subsequently refer back to.
Yeah,
It's not my memory that we're dealing on.
correct.
Perfect. Okay.
That's correct. That's when the clock starts.
Okay, great. Are there any other questions? Senator, thank you for joining us today. We appreciate it.
Thank you.
And if I could have Tyler Govain.
Thank you, Mr. Chairman, members of the committee. For the record, Tyler Govea. I represent the professional firefighters in New Hampshire. Our President, Brian Reel, and Secretary Treasurer John McAllister, who are usually up before you today, are in Tennessee for a International Association of Firefighters conference. So you get me. What we are in absolute total support of Senate Bill 28. As we've been in front of this committee multiple times in the past, the fire service frequently responds to catastrophic incidents involving severe injuries, tragic loss of life, and significant property damage. The cumulative effects of these injuries are well documented and can lead to psychological injuries, including post-traumatic stress disorder, or even in rare cases, suicide. For these reasons, we do urge the committee to support this legislation. I have a few stats that I just want to share with the committee this morning. According to the Journal of Occupational Health, approximately 20% of firefighters and paramedics experience post-traumatic stress disorder. A 2015 study conducted by Florida State University found that nearly half, it was 46.8% of surveyed firefighters have considered suicide. 19.2% have developed suicide plans, and 15.5% have attempted suicide. Those rates are way too high. Individuals with PTSD are 6 times more likely to attempt suicide compared to matched controls. Many firefighters can easily recall multiple harrowing emergencies that just replay over and over and over again in their heads. Research from the Warrior Research Institute, part of the Baylor Scott and White Health in Austin, Texas, highlights a clear link between the traumatic situations faced by firefighters and paramedics and PTSD, similar to disorders as it was brought up earlier with our veterans. Unfortunately, many in the fire service believe that PTSD will resolve itself on its own, or fear that seeking treatment could harm their reputation inside the firehouse, or fail to remain confidential with any information they give. If untreated or misdiagnosed, PTSD can lead to, as we know, very, very severe consequences, including depression, substance abuse, family dysfunction, violence, and even a heightened risk of suicide, as I stated earlier. While it is crucial to seek help when experiencing these high levels of stress, the stigma that surrounds mental health often prevents many firefighters from acknowledging their struggles. Thankfully, the culture within the fire and emergency medical service is evolving. We are working to break that stigma day by day and coming forward with legislation just like this, ensuring that our members receive the care they need to lead and live healthy lives and provide this essential service without jeopardizing public service or firefighter safety. It was once described to me, we have bi-monthly meetings that we host with locals from all around the state. And I was giving an update on this piece of legislation as it made its way through the Senate. And I had a member come up to me and he goes, Tyler, what really it is with this acute and the building of these PTSD events is it's like you have a pipe that's dripping slowly into a bucket. The bucket's collecting these drips, and each drip resembles some sort of PTSD event, something that they would remember. It might take 10, 15 years for that bucket to fill up, but eventually it will, and it will overflow. And unfortunately, that is what we've seen with a lot of our members, is they don't realize they need this type of help until that bucket is overflowing. If passed, Senate Bill 28 would do just that. It would change the date of injury from the date of first exposure to the date of last injurious exposure, or the date of which the employee first knew of that condition. For example, when that bucket overflows. So I asked today to safeguard the health and safety of our members on behalf of the professional firefighters in New Hampshire. I respectfully ask for the committee's full support on SB 28. I thank the committee for their time today. If there's any questions, I'm happy to ask. I will note that Attorney O'Connor is behind me. He is the A team when it comes to workers' comp issues for anything that is the nuts and bolts of the legislation.
Representative Flanagan.
Thank you, Mr. Chairman. Tyler, what are we doing with this bill? What problem are we addressing with this bill? In other words, whether it was, yesterday, 5 years ago, 10 years ago. In other words, part of me thinks, well, when did we first start experiencing the trauma? But the reality is there's got to be a windfall, but not a windfall, but a point in which we say this is it. This is the illness date or whatever. My question is, what does this bill solve?
Well, I would say, and thank you for the question, Representative. And I know Attorney O'Connor could probably answer that a little bit more eloquently, but what it solves is it gives a firm date. You could time out of these types of cases, correct? And that would be the last thing we want, is to have a member with a date so far back that they couldn't go for these comp claims. Of course.
All right, thank you. Representative Granger.
Thank you, Mr. Chair, and thanks for taking my question.
Mhm.
Is it the case that, so it would call this the date of injury, despite the fact that this is the point that they noticed it, correct?
Correct.
So isn't that sort of a legal fiction if it's not actually the date of injury?
I'm sorry, Representative. I wouldn't know how to answer that question. I would probably deflect to Attorney O'Connor for that.
Okay, thank you.
All right. Seeing no further questions, sir, thank you so much for your
Thank you.
testimony. I'd like to now call Jared O'Connor.
Good morning, Mr. Chairman, members of the committee. Thank you. So my name is Jared O'Connor. I'm an attorney with Shaheen and Gordon, and I've been practicing workers' compensation law, representing injured workers and first responders for about 20 years. It's the sole focus of my practice. I've also been privileged to serve on the governor's PTSD commission that was put in place over 5 years ago, from which this legislation arises. I'm obviously here in support of the bill, and I can give some explanation as to why, but really I thought it would be helpful for me to offer myself as a resource to answer any questions you may have. And I guess I would begin, well, I see a hand up. If you don't mind, I wanted to address Representative Flanagan in particular. So you asked, what problem does this solve, right? Why is this even necessary? Because the law already exists to cover PTSD for first responders. The issue that we've seen in practice since the presumption was added back in 2021 is sort of what was described by the senator, which is you've got a worker who has a traumatic event, a primary traumatic event from 10 years ago, 15 years ago. They attended a double homicide. They, addressed dead children over a decade ago. And they never got any treatment for it. They never dealt with it. They never addressed it. They just soldiered on, pushed it down, and worked. And so a decade goes by or more. They finally get to the point where they seek treatment. They go to fill out the workers' comp form to present this as a comp claim, and they say, well, what's your date of injury? Because you have to have a date of injury for purposes of workers' comp. And so they say, well, I guess that all started back in 2009, and they're immediately time barred, because if their date of injury was over a decade ago, they can't present the claim. So what this legislation does is instruct the Labor Department and the carriers to treat PTSD like the disease that it is, meaning like any other occupational disease, cancer, lung disease, heart disease. The date of injury is considered to be the date of first medical treatment for the condition, or the date of last injurious exposure. So that way you have a date of injury that is more recent, so that gives them the opportunity to present the claim, gives the carrier the opportunity to dispute it if necessary, but that way they can proceed and get the treatment that they need.
Representative Flanagan for a follow-up.
Yeah, since you mentioned my name, I'm knowing a little bit about insurance too, is that these insurance companies, if it deferred back 10 years ago, they'd say, we're not your carrier. Go back to your original carrier 10 years ago,
Right.
correct?
Right. Or we never got notice. Without appropriate notice,
Right.
the claim is barred as a matter of law.
Thank you.
Any subsequent questions? Representative Sullivan.
Thank you. Looking at RSA 281-A:16.
Yep.
It says exactly what has been described. And I'm just curious why it doesn't apply to this now.
It can and sometimes does. That's been my experience in litigating these cases, is that in exactly what I've described, which is you've got someone with a particularly traumatic event over a decade in the past that maybe was the initiating factor for PTSD, but for which they never sought treatment. Again, when they file the comp claim now a decade later, they identify that as the date of injury and they're immediately time barred. They can still make the argument if they refile and claim that this is actually more in the nature of cumulative trauma and the date of my first medical treatment was recently. That can and has been successful, but what this legislation does is push the issue so that it is definitely more recent. So that way you don't get into the battle back and forth about which date of injury are we dealing with, which one's more appropriate, which carrier is on the risk. Everybody knows that this is going to be treated like any other cumulative trauma injury, whether it's carpal tunnel syndrome or osteoarthritis. When you first get medical treatment for the condition that slowly builds up over time, that's considered the date of injury. So this clarifies in that PTSD right now is arguably, is it a single event in the past? Is it cumulative trauma? How does this work? Is it a disease? Is it not? This, as a matter of law, instructs the Labor Department and carriers to treat PTSD like a disease, like an occupational disease.
Thank you.
No follow-up? Representative Granger.
Thank you, Mr. Chair. So why does this bill it seems to me that this introduces a legal fiction, right? Like it's saying the date of injury is this, even though the date of injury was factually not that. So why does this not just remove the time bars rather than having like the RSAs force people to lie?
It's certainly not forcing people to lie. I mean, the legal fiction, as you describe it, is sort of it's almost a medical necessity. When you've got a cumulative trauma claim, and sometimes I find it people find it easier to think about this in terms of physical injuries. Like if you have carpal tunnel syndrome, for example, there's not a single day on which you develop carpal tunnel syndrome. It comes on over time with repetitive stress to your joints. This is exactly the same thing, except in the context of a mental injury. So you develop PTSD over time through repeated exposure to trauma. There's no one day which you can identify that someone has PTSD. It grows over time. And so what our law has done traditionally for more than decades for physical injuries is to say that when you have cumulative trauma, you need to have a date of injury, like in any workers' comp case, because everybody needs to be put on notice that a claim is being made to identify which insurance carrier is on the risk. It helps set the timelines to file claims, ask for hearings, sets the appropriate wage for when you are filing your claim. So you need to have a date, which everyone can now pay attention to. When you've got this kind of cumulative trauma that arises over time, what is the one date? The law needs to pick something. And so in cases of cumulative trauma or repetitive stress, the date is, under A16, the date of first medical treatment for the condition, which makes sense because you've got someone with a condition that's building up over time. They finally seek medical treatment for it. Well, if it's gotten to the point where they now need to see a doctor or they're being taken out of work because of it, that does make sense for that to be the date of injury because it hasn't disabled them prior to that. They haven't needed to see a doctor prior to that. But now it's built up to the point where action is being taken. And so it's appropriate to have that be the day. It's the straw. Thank you. See, he said it better than I could.
Representative Cahill.
Thank you, Mr. Chair, and thank you for taking my question. So if we recognize that the people in the fire service now are learning to trying to remove the stigma, and they often have their peers talk about an event after the fact, but that's not quite enough. And it may, over time, lead to the need for professional treatment. And so this bill will help ensure that more people can get that treatment when they do recognize they need it, when they won't have to think about paying out of pocket or their own personal insurance. It will be covered by workers' comp. Is that correct?
That's correct. And I think it's also worth noting that this legislation doesn't just affect PTSD. It also affects acute stress disorder. And the difference between the two is that post-traumatic stress disorder is, by definition, a long-term event. Acute stress disorder is the kind of stress that people experience immediately after trauma. Mm-hmm. And so the idea here is that if someone experiences a traumatic event and needs to seek medical treatment, that they will immediately, the claim will be covered, they'll get the treatment they need. And the studies have shown through our work in the PTSD Commission, what we've learned over time is that when people recognize that they have been exposed and are having this kind of mental trauma, the faster they get treatment, the more likely it is that their symptoms will be managed and they will be able to return to work and not be out on disability for long periods of time. You get in quick, you get treated, and you can get back to the job. ideally, that's what this is intended to do, is to get people the treatment they need quickly so that you're not looking at situations where people are having career-ending injuries.
Thank you.
Any other questions? I do have one question. I'm sorry, Representative Labrie, go ahead.
Just had a question on projected cost implications of this. I would imagine if this goes into law, that you're going to have a run on, probably rightfully so, you'd have a run on PTSD claims to the comp. So from a retro perspective, how's this going to affect the taxpayer? Is this going to be a run on comp claims that's going to drive insurance through the moon, or how do you see that?
I honestly don't think that it's going to make that much difference in the way that people present their claims or the number of claims that are presented, because the people that are finally admitting that they have PTSD and are seeking treatment for it, they're already filing comp claims. What this legislation does is just clarify what the date of their injury ultimately is. If this legislation passes, it's not going to force someone who isn't already seeking treatment to start seeking treatment. The medical records will bear out as to whether the person legitimately has PTSD or not. And that's something that the carrier always has the opportunity to challenge. Just because the presumption exists doesn't mean that every claim is automatically accepted and paid. It means that the carrier has the opportunity to investigate the claim and determine whether this person, A, legitimately has PTSD, and B, if it really is because of work or whether it's because of something else. So that doesn't change the landscape of the way the cases are litigated. I can't say there'd be no financial impact, but I haven't seen, since the legislation was passed introducing the presumption in 2021, and there was testimony about this in the Senate, so you could pull the record from over there, but the amount of claims that come before the department for PTSD, I'm just one person, so I can just tell you from my own experience, at any given time over the last 3-4 years, I have had 3 to 4 at most active PTSD claims or clients. So I haven't seen a flood of these kinds of claims. I mean, again, the idea is that people will file the claim, get the treatment that they need, and not be out for very long. I mean, if you get treatment quickly for a stress disorder, then it's a month or 3 of treatment, and then you're back to work. And that's what the carrier is paying for, is medical treatment, as opposed to long-term PTSD, where they potentially could be out for a longer period of time. Sure.
All right, Representative Dago, did you have a question?
Thank you, Mr. Chair. You kind of described it as kind of closing I would say like a loophole that somebody can say, oh, my issue happened in 2005 and now you're no longer covered. How often have you actually seen that those claims to be denied because of that?
I've seen it personally, again, and given that I'm only one person, I can only handle so many cases, but I've definitely seen it at least 3 or 4 times where people have had a primary trauma a decade or more in the past. And then they go on to have ongoing trauma because they never dealt with it, they never got treatment. They continue to work full time for the following decade or more. And then they're subject to additional trauma. And they're seeing things repeatedly over those decades. And it finally builds up to the point where they now break down and they find themselves unable to go into work. They find themselves having stress reactions, and they're no longer safe to do the job. They're neither safe for themselves or the public. And so that's what forces them into treatment. When they finally get that treatment, they are discussing not only the recent trauma that pushed them to that point, but the first trauma that they had, as their, second year on the job. And having that be the initiating event, or at least the first time that something like this happened, they may still be having nightmares and stress reactions to it. And so because of that, when they fill out the comp form, they say, well, this all started back in 2012. Even though that isn't the only thing that ever happened to them, it's been building up over time through repeated exposure. So it definitely happens, and I've seen it happen.
Any other questions? I did have one question. Just so I have PTSD that I've noticed today. 10 years ago is when the primary event incident or the first claim that's on record that would apply under this law. would I be eligible for back pay for workers' compensation, or is that just going
No.
forward?
No, no, no. No,
Okay.
you're not. You can't get back pay prior to the date of your injury because that's when you were injured. Anything that happened before that may have led up to the injury.
But what we're defining as an injury, the start date
That is
10
very
years
recent.
ago.
No, no, no. The date of injury is the date of first and that's the legal fiction that you're talking about. Is that the date of injury is 6 weeks ago when you finally went in to see the doctor. It may have all started as a medical matter a decade ago, but the date of injury for the
Is
purposes
still
of
that-
workers' comp is from 6 weeks
Okay.
ago.
All right.
And so that's when the carrier becomes responsible to pay medical going forward. So yeah, you're not talking about reopening medical bills and periods of disability from ages in the past.
Okay, thank you for that clarification.
Yeah.
Thank you, sir, for your testimony. I'd like to now call Mr. Burke.
Good morning, Mr. Chair and other members. My name's Gary Burke. I work for the Department of Corrections. I'm a captain there at the State Prison for Men. I've been there for 20 years. I just came today. I do have some handouts if anybody would like them. We are in support of SB 28. The prison is a very unique job for anybody to do. We see trauma right out of the gate. Several new staff, we have 50% of staff have 4 years or less. They may not recognize the stress of the trauma that they're exposed to. We have assaults, we have stabbings, we have suicide attempts, we actually have loss of life. You may be assaulted, urine and feces are thrown at you. The interesting thing about our job is we may see somebody commit suicide in one of our units and there's blood and all sorts of things that you can see on the floor. But right now with the state of corrections, the short staffing we have, we're doing 4 to 5 doubles a week. So you don't have time to unpack that baggage. So this bill would be crucial because we have new people who don't really understand what stress and trauma is. And there's a culture inside of the walls and the silos that we work in of not saying that you're not okay. I'm a part of a group called One Voice. I've been to Norway, I've been to Washington, I've been to Philly, and we're talking about corrections and breaking the barrier and saying that we're not okay and that we've been exposed to trauma. And for my whole career, starting in 2004, it wasn't okay to say that you're not okay, right? We have military individuals who bring their PTSD or their baggage from the military. We have people who haven't been there and it's exacerbated. Again, I have handouts for anybody, but some quick stats. I know what the firefighters talked about, and I think our brothers and sisters need it too. PTSD amongst correctional custody staff is 34%. Depression for correctional staff is 31%. Right now in this country, I know we're talking about New Hampshire, but nationwide, 3 corrections officers commit suicide a day, directly to the impact and the trauma they've seen over their correctional career. The lifespan for a correction officer is 59 years versus 75 for the rest of the world. This is something that we think this bill will help impact because we need officers to be recruited. It needs to start. Our hope is that people will come forward and say they're not okay. And I'm not a legalese, I'm not an insurance expert, but my hope is that maybe this starts some type of program as well, where if people are worried about liability, they start some type of education for people in an academy through their career with follow-ups, letting people know to claim an injury. And it's okay to come forward and to get you some help to return you to the workplace. The physical manifestations and psychological manifestations, if we start in our job right now, because of the retirement changes in 2011, they've got to do 25 to 32 years. We are losing 50% of staff between year 4 and year 5 because they have 7 years experience with the overtime. And you can imagine the trauma that they're exposed to. 16 hours a day, you have an hour drive, people are getting 3 hours of sleep a day, coming right back into that environment the next day. You might be forced for another overtime shift, and it's in the same unit that you saw that traumatic event, and nobody's talking to you about it. And you may look around the room to a bunch of people who are hardened like steel because they're desensitized because of the years of violence and stress that we've seen inside the walls. And so the new corrections officers are also taught basically by the culture to not say anything. And you'll look around the room and say, well, I must be okay because these guys just saw 2 people with a suicide attempt, blood all over the floor, and here they are eating a chicken finger dinner 10 minutes later after the event, right? People haven't recognized the trauma, senior staff, spent 15, 20 years like myself saying, don't talk about it. So I don't want to talk too long. I do appreciate everybody's time. I believe that this is a very important bill for corrections. I'm happy to answer any questions to the best of my ability, but we fully support this and think that this will lead to great things going forward.
Great, thank you for your testimony. Representative Flanagan.
Thank you, Mr. Chairman, and thank you for your testimony, and thanks for coming out. My question for you is sort of a simple one. I don't disregard your testimony, I think is needed. Okay, but the way this bill is written, it says emergency responder. Is there a state classification that says prison guards are considered emergency responders?
Yes, sir. So when we went through COVID, they defined what first responders were.
Oh, okay.
And corrections was under, we do meet RSAs for being first responders. Thank you, sir.
Representative, do you have a question? And your name? Representative Ryan, thank you. That was my question. You're good. Okay, great, thank you. Representative McKenzie.
Thank you, Mr. Chairman. Thank you for coming this morning. The question I have is if you could describe the kind of the way this is all going to fall apart. And I say that, if I could, in the context of the reduction that is being proposed for the state prison. My understanding is they are talking about, so you're going to have less people to rotate through. You're going to have less people for overtime, correct?
Yes, sir.
And do you see that as having a significant impact on the staff and the ability to perform and do the job without additional problems that are going to manifest themselves?
Yes, I believe it's going to be a problem. So they were talking about 150 positions. I believe they're talking around 92 that actually physically have bodies in them. Some of them are my members, and two of them right now I met with this morning. They're recruitment and retention officers, and so we're trying to get mental health into the academy, talking about it to new people, trying to teach your family members to recognize the signs that you're under, because they're going to notice you changing at home from what you see at the workplace. I think that every member is valuable, and we're getting to a place where members can start, staff, whether you're blue shirt or civilian, to say that you're not okay in the workplace. And it is going to be exacerbated. And people may say, well, why? Because there's not a big reduction in blue shirts, right? Corrections officers. My first comment is any reduction in corrections officers shouldn't happen. I was part of the cuts in 2009 to the Laconia state facility that was there. And we still haven't recovered from all of the corrections officers they laid off. They did 2 rounds of layoffs there. People left. The reputation to come work for the state prison. I was at Merrimack County for a year and a half. Nobody wanted to come, even though we had some really solid officers there, I thought, for the year and a half I was there, because they were worried about getting laid off, right? Then they were worried about changes to retirement. We have construction projects right now. Capital budget, as you know, the commissioner is trying to get a new prison in because our facility is very old. Today, they were just told, hey, we need 5 corrections officers to watch these civilians come around and do maintenance projects. So you're forcing 5 people to be pulled off of doing what we do for a living, right? Care, custody, control of inmates, to watch construction projects. And now you just told 5 other corrections officers they can't go home, and they're going to do another double. And a couple of them just did 3 in a row, and they're hoping to get a break, right? But that continues. So I think it's just going to exacerbate an already bad situation. Obviously staff are saying, hey, just a year ago, we were giving $10,000 sign-on bonuses. Now everyone's got the stress of worrying about who's going to be there tomorrow, who's losing their job. Right. And the cuts aren't as simple as position numbers, because there are, through a union perspective, bumping rights and things of that nature. But yeah, I don't think it's definitely not what the state prison needs at this time, sir.
All right. Any other questions? Seeing none, thank you, sir, for your testimony and your service.
Thank you, sir.
And Miss Albert, batting cleanup as always.
Good morning. My name is Danielle Albert. I'm the Deputy Commissioner of the New Hampshire Department of Labor, and I will be brief. I'm not going to echo, I'll try not to echo or repeat testimony that's already been given. So the department has reviewed this bill. We're neutral on the bill. We understand the proposed intent. We believe that it is something that we're able to regulate as written. To echo Attorney O'Connor, somewhat we understand the language that's being added through the bill is crystallizing or making very clear that for the first responders as defined by the workers' compensation statute, their dates of injury are going to be set in line with what the parameters of 281A16 say relative to occupational diseases and cumulative trauma. And with that, I am happy to take any questions that there may be.
Representative Granger, go ahead.
Thank you, Mr. Chair, and thanks for taking my question. So let's say that you have a certain provider, excuse me, a certain provider for workman's comp, and you start engaging in this cumulative, then 10, 20 years later, you have a separate provider for workman's comp. And then the date of injury is while you have the second provider. Which provider provides the workman comp?
When you say provider, can you clarify for me? Do you mean medical provider or insurance carrier provider?
Insurance.
It's going to, the insurance carrier who's going to be liable for the injury, it's going to be dictated by what the date of injury ultimately ends up being. So if the language is dictating that it's the date, you know, if you're making the cumulative trauma argument, it's the date of first medical treatment, it's that date. It's the policy that was responsible for that date of injury that's going to be responsible for the injury that may come out of it.
Yes, sir.
Thank you. And thanks for taking the follow-up. So would this bill, as it's written right now, require workman's comp insurance providers to cover pre-existing conditions?
And by providers, again, you mean the insurance carriers?
Yes.
Oh, I'm not sure I know exactly what you mean when you say pre-existing conditions. Can you clarify that for me?
So if you already have PTSD and you decide to seek treatment sometime down the line with a new provider, then this is a condition that existed before you had that insurance provider.
Are you talking about it in reference to PTSD that is unrelated to some type of work exposure or work-related injury, or are you talking about the PTSD that is resultant from the exposure to the work-related events?
So does the, well,
Forgive me, let me perhaps clarify my question back to you, so forgive me. I think when I think pre-existing condition, I'm thinking about something that's perhaps unrelated to a work injury. I'll use a more concrete example. I hurt my knee playing soccer in college. I go to work, I have a knee injury. Disputes of that nature arise in the workers' compensation context frequently, and then there's evidence to look at and medical opinions to determine whether or not the insurance carrier is liable for the work-related aspect of the knee. If what you're asking is, I had an unrelated mental health condition, and then I am working and I have exposure to traumatic events that ultimately result in PTSD, and I treating with one doctor for my unrelated condition, my unwork-related condition, I then treat with a different doctor for my work-related condition. If the question is the insurance carrier going to be liable to cover the unrelated condition? Arguably, no. Again, it depends on what medical evidence ultimately ends up supporting. If the question is, I have the PTSD and it's stemming from a work-related injury I'm treating and that's not clear, I see another provider and it becomes more clear. Again, it's going to depend on what the medical, it's going to depend on how you apply that language of date of first medical treatment. So again, in those situations, if your first medical treatment happened with the earlier provider, that would set the date of injury. And if that date of injury is not challenged or is found to be the compensable date of injury by the Department of Labor, benefits and medical treatment going forward would be the responsibility of the insurance carrier who had the policy covering that date of injury.
okay, thank you.
You're welcome.
Representative Cahill, go ahead.
Thank you, Mr. Chair, and thank you, Deputy. I think what my colleague across the way was trying to get to is you have a claim with one insurance carrier, and then sometime later, there's another carrier, the department has switched or you're working with a different department, is which one is on the hook for the recent claim? I believe it would be the current carrier, and the prior carrier would have been responsible for the initial claim. Is that correct?
If you have two claims, like you're asserting two different dates of injury, that could be correct if you have two different dates of injury. The question's going to be, if whatever you're claiming later, does it relate back to the original date of injury? That's going to determine which insurance carrier is responsible.
Thank you.
Okay, and I'm sorry, I'm sorry, Representative Flanagan, go ahead.
Somewhat unrelated, but firefighters are human. And there's no doubt that this bill is certainly required. But as an insurance company progresses on paying claims, and that's what they really do, is they write checks. My thought process is, do they delineate the stress? Like, say I'm a firefighter, but I'm going through a divorce too, and that's behind me, but I'm still haven't gotten past it. And all of these, accidents and accumulate. Does the insurance company sort of pick and choose? And this is just sort of a generic question. Do they sit there and say, well, his stress is related to his divorce and it's not related to the claim? I know this. Do they actually do things like that?
It's an excellent question. I'm a little bit hesitant to answer on behalf of the insurance industry since I'm not directly working for them. Certainly, I would say in my experience at the department, we have seen claims not just for mental health injuries, but for a variety of physical injuries as well, where an insurance carrier in undertaking, the due diligence that they go through in determining whether or not a claim is their liability are raising this does not appear to be related to work. It appears to be related to something else. So can it happen? Arguably it can. To what degree or what steps insurance carriers go through in looking at it that way, I'm not certain I'm the best person to answer.
And Representative Kessler.
Thank you, Mr. Chair. So you said at the beginning of your testimony that the department would know the changes, or you guys would be able to make the changes. Could you outline some of the specific changes that would need to be made for this bill?
Yes, that's a really good question. We anticipate that the area that the department would see primary change in the regulation, if this were to pass in its regulation, probably, through the administrative hearing process when disputes arise. If there is a dispute about whether or not the claim is a compensable one or what the date of injury of that claim is, more likely than not, we would see it through the administration of that hearing process. And so it would be then application of the change in language through the adjudicators, the hearing officers who are hearing those cases. I mean, other changes that come along with that, the insurance carriers, as well as, to the extent injured workers are aware or their counsel are aware, would need to know about the change such that they're able to apply it at the stages that they're at. But most likely where the department would see it would be in the context of disputed cases.
Okay. Representative Avalani.
Thank you, Mr. Chairman. Thank you, Deputy Commissioner. The question I have is if we have numerous workmen's compensation policies through the years of the 20 years, would the current policyholder or policy maker be eligible for the secondary injury fund to recoup some of their losses for the current situation, given the fact that it was a 10-year ago and might have been a prior carrier or a prior injury or a prior department? Would they be eligible to recoup some of their losses from that fund because it's technically is a secondary injury?
That's an excellent question. Potentially, it would depend on the eligibility criteria that's attendant to making a second injury fund claim. So there are certain eligibility criteria that an insurance carrier has to demonstrate when they're claiming a second injury for eligibility to be reimbursed from the fund. So it would be dependent upon a host of different factors, inclusive of meeting that eligibility criteria.
Thank you. Thank you, Mr. Chairman.
Representative McKenzie.
Mr. Chairman, I wonder if the commissioner could just explain the second injury fund, the purpose of the second injury fund, because I'm not sure.
Sure.
That's a good question.
Yes, so the second injury fund, I really think its technical name is the Special Fund for Second Injuries, but it's most commonly referred to as the Second Injury Fund, is a fund in which insurance carriers, both voluntary and self-insured, make payment into every year through an assessment process that's set by statute. And then if that insurance carrier, again, does not matter if they're voluntary or in the self-insured realm, if they are able to make out, they can file an application, and if they can make out a claim that they have a qualifying claim for reimbursement, is then able to submit to the department through the Second Injury Fund coordinator a request for reimbursement for certain types of workers' compensation costs paid. So not all workers' compensation costs are eligible for reimbursement out of the fund. The statute makes clear certain things such as permanent impairment awards and vocational rehabilitation benefits cannot be reimbursed out of the fund. But if an insurance carrier can demonstrate that they have a qualifying claim after they meet a $10,000 deductible amount, they're eligible to file for reimbursement for indemnity, that's paid, medical, that's paid. The reimbursement amounts come in 50% up to the first 104 weeks of indemnity that's paid, and then thereafter it's 100% of those costs that are paid. The purpose of the fund, if you're kind of going back historically, why does it exist, is to provide an incentive to employers to hire and retain individuals with pre-existing conditions.
Representative Granger.
Thank you, Mr. Chair. So let's say you're a prison guard and you have all these specific events happen and they're fairly traumatizing, but then you decide to stop being a prison guard and you work as a software engineer or something like that, something that's fairly non-traumatic. On the job market, since you now have additional workman's comp liabilities attached to you, might that make it harder for you to get a job? And wouldn't employers need to actually dig into your history to see if, from their perspective, you're a landmine that's going to cost them a bunch of money?
It's a good question. I'm hesitant to answer on behalf of employers and how they approach hiring employees, given I don't want to collectively speak for that body. As it relates to if we're coming off of second injury fund determinations, certainly the second injury fund program, it is the type of incentive that addresses those types of situations. But as far as what are employers looking at, there's a host of employment laws that apply outside of the context of workers' compensation about what employers can and cannot look at or ask about in relation to conditions and injuries and things of that, disabilities and things of that nature. So I don't know that I can answer how employers are approaching that.
Thank you.
Representative McKenzie.
Thank you. Commissioner, the current law, as I understand it, says that you have, from the time you knew or should have known, you have 3 years to report the injury. And then you have a year to file a claim once you report the injury, correct?
I believe it's 2 years to notify the employer and 3 years to pursue the claim, I think is the timeframes.
So how does this, so an accumulative trauma kinds of things, fit that into that?
Yeah, so I think to kind of echo what Senator Birdsell had explained on introduction of the bill and what Attorney O'Connor had explained, if you have somebody who has and to kind of use this, insidious onset, the sort of slow, incremental, it's kind of difficult to pinpoint. When you're looking at the last date of injurious exposure, or you're looking at the date of first medical treatment, you're not going all the way back and pinpointing that, date that all of that happened. One, in these cases, I think that can be a difficult date to pinpoint because what exactly was that date? If you, to kind of echo Attorney O'Connor, if you reduce it or put it within the framework of something more physical, repetitive stress, you tend to think about joints. I'm moving my joint. When did my joint first start to twinge? I don't really know, but what I do know is when I first went to the doctor for it. So because this language would set the date of injury at that date of first medical treatment or date of last injurious exposure, your clock starts running from that date.
Also inability to do the job.
Pardon me?
I'm sorry. Representative Flannery, did you have a question?
Yeah, it was. Thank you. That's also the inability to do the work. Workers' compensation pays you because you can't do the job.
If you have a compensable workers' compensation claim and you're disabled from work as a result of that injury, yeah, the insurance carrier can pay work replacement or wage replacement benefits.
Okay, seeing no, I'm sorry, I got to ask the same question again to make sure that I'm tracking. And that is that if I apply today and I say that this started 10 years ago, under this law, is there a chance that back payments would have to be made for that time period from 10 years ago to today? Or it just starts from today and forward?
Yeah, it's an excellent question, and no, they would not be. So the insurance carrier liable for the claim is not required to go backwards from the date of injury to pay lost wages, medical benefits, or anything of that nature. So
Okay.
there would not be sort of back benefits in that regard.
Okay. All right. Seeing no further questions, thank you for your testimony. And we're going to close the hearing on SB 28. And I'm going to open the hearing on SB 67. And,
He's going to introduce the bill.
okay, great. And I'd like to have Mr. Peter O'Neill introduce on behalf of Senator McGough. And sir, the floor is yours.
Thank you, Mr. Chair and members of the committee. My name is Peter O'Neill. I'm the Communications Director in the Senate. Very nice to be in the House this morning, and I'm filling in for Senator McGill. This is Senate Bill 67, and it addresses a timing issue in our current workers' compensation laws. I'm going to read a brief introductory statement here, and I cannot take any questions because I'm not the prime bill sponsor. Under the existing system, when a work-related injury occurs, insurance carriers and self-insured groups are required to pay the reasonable value of medical services provided within 30 days of receiving a bill from the medical provider. And here's how that typically works. Number one, the medical provider submits the bill. Number two, the insurance carrier or self-insured group evaluates the bill using in-house or third-party references to determine the reasonable value of the services. And number three, a payment is issued to meet the 30-day statutory deadline. To protect medical providers from being underpaid, the law allows them to dispute the payment amount. However, before a formal complaint is filed with the Department of Labor, the insurance carrier or self-insured group must negotiate with the provider and make every effort to resolve the issue. If the dispute isn't resolved, the provider can then appeal to the Department of Labor for a hearing. At that hearing, the commissioner determines the reasonable value of the services. Neither side typically wants to go to a Department of Labor hearing because the outcome is usually uncertain. It's better to negotiate a mutually agreeable resolution than to take the risk of an unfavorable decision. Senate Bill 67 seeks to address one gap in this process. While insurance carriers and self-insured groups must pay bills within 30 days, there's currently no time limit on when medical providers can dispute those payments. You'll hear testimony today from representatives of self-insured groups explaining how they've received disputes and after payments were made, after claims were closed, and even after surpluses were returned to member companies. It's important to note what Senate Bill 67 doesn't change. It does not eliminate requirements to pay the reasonable value of services. It does not alter the 30-day deadline for payments. It does not remove providers' ability to negotiate the disputes, and it does not take away the right to appeal to the Department of Labor. All Senate Bill 67 does is introduce a reasonable time limit, which is outlined as 90 days in this bill, for a filing and appeal. This is 3 times longer than the 30 days insurance carriers and self-insured groups are given to make that initial payment. This legislation strikes a fair balance between a timely payment and reasonable deadlines for dispute of the resolution. And thank you very much for considering Senate Bill 67. And one other thing I would add is that interested parties have agreed on an amendment to change it to 45 days. And like I said, I cannot
I'm sorry,
take any questions.
one second.
Yes,
This reads 45.
correct.
I think the amendment says 90.
That might be the case. I'll have to confirm with Senator McGill.
Okay, because what I'm reading says 45, your testimony said 90.
Yes,
But I believe I think it's flipped.
that might be the case. I'll confirm with Senator McGill for the committee.
Okay, I just want, for clarification, I want to make sure we're straight.
Sure.
Okay. All right, thank you
Mr.
for
Chair-
introducing the bill. We appreciate it.
Thank you, Mr. Chair.
Mr. Chairman,
Who's that?
I'm
Yeah, Representative Sullivan.
following up on the same issue. The front page under analysis says 90 days, which is on the original bill as introduced. So frankly, I'm confused.
Yeah, and as you should be. Can you do me a favor and clarify what we should be reading while we hear testimony, and then come back and clarify what this should say?
Absolutely. Let me chat with
So you
Senator
got
McGill
about
and get
20
that
minutes. If
confirmation.
you can sort that out and come back, that would be awesome.
Of course.
Okay?
Absolutely.
Thank you. Appreciate it.
Thank you, Mr. Chair.
Great. Good catch. We're going to hold questions right now. Okay, go ahead.
Thank you, Mr. Chair. I understand there's almost 2 parts to this. The first part meaning that the healthcare provider has a certain amount of time to get back to the insurance companies. And then after the dispute is in place, if I understand correctly, there's another 90 days to go and complain to the Labor Department to get a hearing on those monies that might be due. But Senator Bragdon, retired, may have more information because I think he was sort of the go-to person on this. And I say he gave a pink card, and you may want to talk to him about that issue.
Okay. All right. Please go ahead and you do your verification. Come back in 20 minutes, and then we'll listen to testimony, and hopefully by the end of this period, we'll know exactly what we're looking at.
Absolutely. And I
Okay.
suspect the people behind me probably have a better understanding.
I'm sure they do, but I appreciate your help.
Thank you, Mr. Chair.
Representative Sullivan.
The other thing I'm noting is that there are two 45s in the bill itself, and I believe they're probably addressed in aggregate,
Okay.
which should give you 90 days.
All right. Cool. All right. We'll see you in a minute. Thank you so much.
Thank you.
And Representative Woods.
Thank you, Mr.
The floor is
Chair.
yours, sir.
Thank you, Mr. Chair, and thank you, committee. My name is Gary Woods. I'm a representative from Merrimack 30, serving Concord. It's Floterial. I get the privilege of doing warrants 5, 6, 7, and 8, so I do a little running around. In my previous life, I was an orthopedic hand surgeon, and that's part of the reason I'm here. I practiced 34 years here at Concord Orthopedics. Retired 11 years ago, and now I'm retired. Along the way, as part of my previous life, I got involved with workers' comp. Back when Governor Judd Gregg was governor, and the infamous or famous House Bill 1409 completely restructured workers' comp. I was part of that for 15 years and chaired that committee for 5 until at 65, I decided that time for somebody else. 65, I thought was getting up there, but now being 83, 65 looks actually pretty good. But be that as it may. Along the way, we had 2 reviews. This had to do primarily with payers. Patients. And those reviews, how patients were better cared for. As when I was chair, I said, well, this is really a medical board, and our charge is to take care of these patients. They just happen to be injured at work. As a consequence, the review process really improved. We had another internal review at the committee, and there may be people from the committee here today which would give you an update on how their activities are going. But be that as it may, this is another step in that process. And although I put on the card that I'm against the bill, only from the standpoint of the timeframes that are involved and the way it's worded and how the clock starts on some of those timeframes. And I'll explain just very briefly. My sense is that this is something that's perhaps overdue. We can all make the system better, and when I was on the commission, we sought to do that on a regular basis. To me, this is one step in that process of making the workers' comp system better for patients, because the real downstream is that if this gets worked out well, it'll actually help patients get their care. And that's really what we're after. So my brief comment is just going to be that, number one, the time frame is too short from what I understand. And my previous, again, retiring 11 years, I'm not with it anymore. But that is too short from some of the vicissitudes of getting bills paid and reviewed and they're recommunicated and negotiated and so forth. It's just not reasonable. The second thing is the way that it's worded. It says the healthcare provider has notified. How is that supposed to occur? I mean, I can send an email, I can send a registered mail, and the time frame, when does that start? The third-party payer says, well, I didn't get your letter until just last week. Well, I sent it 10 days ago. When does the clock actually start? So we have to have some way to verify the clock has started. Because, I'll be honest with you, both sides of this equation can game the system. There's no system devised by human hands that hasn't been gamed, and there will be attempts to do so. I think this is a step in the right direction, but I think the time frame overall needs to be extended, and I understand there's amendments that are in process, and I think that's good. But also, word has to be clarified exactly when does the clock start, and I think that's going to be important. I'll leave it at that with the idea that if there is no one here that's actively with the Workers' Comp Advisory Council, that might be a group that would, if you're for example, put this to interim study to try and get some of this clarified. That would be one source I think would be quite good. And I'll leave it at that. I can't answer a lot of detailed questions, but happy to.
Well, sir, just real quick, when would you recommend the clock start based on your experience?
Well, I would leave that to the people who are actually doing boots on the ground as exactly, that would be part of that process.
Okay, and what time frame would be reasonable from your perspective?
Again,
So you just think it's too short and there should be a start clock, but you don't have a suggestion?
I'll pick a number, because it's going to be picking a number, 90 days.
Okay, great, thank you. And Representative Cahill, go ahead.
Thank you, Mr. Chair, and thank you, Representative Dr. Woods, for taking my question, and thank you for keeping your hand in. So, all right.
My tie's
I
appropriate.
gotta pass
I
for that.
yield the floor. Go ahead.
Oh, thank you.
I withdraw go ahead.
Okay, so are you thinking that the clock should start when the notice was sent? You know, in the case of an email, or you have a date that you sent it, is that a reasonable place for starting the clock?
I'm really going to stay out of that, because that's the way our systems are these days. It's very complex, and it's going to be very different for a private office versus someone who is employed by a big corporation and is part of a corporation, and that's totally different kinds of systems. And so to have them match exactly how the clock gets started, it's going to be the mechanism by which that occurs. And I would leave it to the people behind me to identify how that can be defined.
For follow-up, sir.
Yep, actually, if I may, yesterday my wife received a notice for that she owes somebody $36. It's from December of last year. Thank you.
I can believe it.
Okay, any other questions? I saw you wave. Okay, got it. Thank you, sir. Appreciate your time and coming in and talking to us.
My pleasure. Thank you.
And if I could have Mr. Vialis.
Good morning.
Good morning, sir.
Sorry. For the record, my name is Nick Valis. I'm the CEO of the Bedford Ambulatory Surgical Center and some other healthcare facilities. And I oppose this bill. And the primary reason is I believe we have come a long way in workers' compensation, and that our fee schedules are becoming reduced, so to speak, meaning our premiums. And compared to other states in New England, we are just about as good as it gets. And that all happened because of some legislation that allowed people for the first time to negotiate. And healthcare providers, private healthcare providers, we're buried in regulations. And more regulation isn't going to solve. This, to me, is a solution looking for a problem. Most of the groups that we deal with that are the insurers, and as well as the workers' comp insurers that are, and some of the workers' comp trusts, the Lawson Group, for an example, is a large provider of services in this space, we have no issue with. There are some, though, self-insured TPAs that are difficult to deal with. and it takes a lot of time. So putting a time limit that seems to be okay may sound great, but I don't think it's going to solve. I think it only sets up gamesmanship, if you may, on how to avoid paying a claim or paying a reasonable claim. So with that being said, I don't think we need more regulations. For some reason, we tend to go there. That's why we have a Department of Labor. And I could actually see this bill increasing the workload for the Department of Labor in time. So with that being said, I'd be more than happy to answer any questions.
Representative Granger.
Thank you, Mr. Chair. Do you think there should be absolutely no limit, or would you be comfortable with like a 1-year limit?
There's actually an 18-month limit for patients, so mirror that.
Thank you.
Follow what we require of the patient. That would only seem fair. But I think I'm not a big regulation guy at this point in healthcare, and I think less regulation is actually better. Any other questions?
Okay, Representative Sullivan.
You mentioned the 18 months for patients. What is that timeline for?
It's basically to resolve your claim.
What does that patient follow?
For a follow-up.
What does that patient need to do within 18 months?
Pay their claims, resolve their claims.
Follow up again.
Okay.
It doesn't seem that the patient is paying claims.
Sometimes if the patient is liable, meaning all of a sudden it's not resolved because it's no longer a workers' comp claim, okay, they are responsible for it.
Just one more.
Sure.
One more. Go ahead.
So basically, you're saying if the patient was improperly paid, they need to repay.
Correct. Or a paid amount. If the patient liabilities are basically, they get 18 months to resolve the claim, their personal liability.
Okay. All right. Seeing no further questions, thank you, sir, for your testimony. I appreciate you coming in. And Peter Bragdon.
Thank you, Mr. Chairman, members of the committee. For the record, my name is Peter Bragdon. I am a recovering legislator and also a senior policy analyst with Pretty Strategies here in Concord. Here today representing the Lawson Group, whose name has already come up by the prior speaker. And just trying to find my notes, if you give me a second here. Here today, like I said, representing the Lawson Group. Lawson Group is a company based in Concord, started at Mr. Lawson's kitchen table many years ago. It's really a true New Hampshire small business success story, now employing dozens of people in the Concord area, providing safety and health consulting, and also as a third-party administrator for workers' compensation for several larger companies, but more importantly, several what are called workers' compensation self-insured trust or self-insured groups, which are groups of smaller companies who band together to pool their resources to not only try and get better rates for workers' compensation, but to take advantage of some of the services offered. There are 3 of these workers' compensation trusts that the Lawson Group manages. They're typically, like I said, smaller companies. They're not big enough to self-insure on their own. And so typically smaller companies. We have trusts for the lumber industry, so covering anybody who's from those who are out in the woods cutting down trees to the lumber mills that turn them into boards to the lumber shops or hardware suppliers in New Hampshire, the local businesses that do this, not the Home Depots, not the Lowe's, the small guys. I think if you have a lumber company in any of your districts, likely they're a member of the Lumber Trust. There's a trust for manufacturers, for businesses that that produce products based on other products, take raw materials or other products and make something out of them. And there's a third trust for health and human services providers. More than 400 of these companies belong to the trusts that we administer at the Lawson Group, covering some 35,000 of our friends and neighbors, providing workers' compensation insurance. I will mention that other trade associations have their own self-insured groups, for instance, the auto dealers, the Lodging and Restaurant Association, New Hampshire Motor Transport, and Primex, who covers cities, towns, and school districts for the workers' comp. The philosophy for self-insured group, and especially the Lawson Group, is the least injurious, least expensive industries are those that never happen. So we spend twice as much as the industry standard on loss control and loss prevention, because if we can keep the accident from happening, if we can keep the injury from happening, then that only helps people out just personally, but it also helps financially for the workers' comp payments. This results in fewer accidents and lower payments, which means at the end of the year, there's a surplus that's returned to the members. In our case, and I think a lot of these groups do this, there's an annual meeting at which point physical checks are actually handed to people as a return for their good work in keeping the claims down. As was mentioned by the introductory speaker, the current situation is if a worker is injured, then the medical services are provided. And by the way, for years, and I still do this sometimes, I use the word provider, much like came up before, right? Provider, some people think as being the insurance provider, some think of as being the medical provider. So I use the word carrier for the insurance company and provider for the medical provider. So medical services are provided, and then the provider sends the claim to the carrier, which in this case is the self-insured group. We have 30 days to pay that claim. I should say we have 30 days to pay, the law says, the reasonable value of that claim. Prior to, and Representative McKenzie probably remembers the exact date, the early 2000s maybe, I think the workers' compensation law was that the carrier had to pay the bill no matter what it says. And of course, that led to a lot of, some would argue, high costs. So the law was changed to say 30 days has to be paid, has to pay the reasonable value, but to provide protection to the providers from the carriers lowballing them, there is an appeal process built in. The provider has the opportunity to contest the claim. The law says if that happens, both sides have to negotiate, make all reasonable efforts to resolve the dispute. And if they can't resolve it, then a provider can appeal to the commissioner, and the law says the commissioner has, quote, exclusive jurisdiction to determine what that reasonable amount will be. I would say that in most cases, neither side wants to go to the commissioner because you just never know what the commissioner is going to decide. So you'd rather come to a settlement, come to an agreement, and rather than take that risk. The problem we're seeing is that literally years after we've paid the bill, the provider says, oh, we dispute this, we want to take this to the commissioner. Keep in mind that this happens after the claim has been closed, after the year has been closed for the policy year, and the actuaries have done all the work calculating what reserves are needed, and more importantly, after the surplus has already been sent back to the members. So we think that obviously having no window there is not reasonable. What Senate Bill 67 looks to do, and I can address some of the issues people had about what the bill says. The bill as introduced, the title says it establishes a 90-day time limit. That 90 days consists of two 45-day periods. So you add two 45s together, you get 90. The original bill allows for 45 days. So from the time the payment is made, the provider has 45 days to notify the carrier that, hey, we disagree with the payment you gave us. We want to negotiate. And then it gives another 45 days for those negotiations to happen, at which point, if they haven't come to an agreement, then the commissioner, apply to the commissioner. But after that, you just can't be dragging stuff up long after it's happened. We felt 90 days was a reasonable amount altogether. It's 3 times the amount of time we have to pay the claim in the first place. As the Senator McHugh's testimony noted, this does not remove our requirement to pay the reasonable value of the claim, does not remove our requirement to pay within 30 days. At all times, the injured worker is covered. There is no liability on the injured worker's part. This is all being covered. This is between the carrier and the provider. And it does not remove the provider's option to negotiate with the carrier, and does not remove the provider's option to appeal to the Department of Labor. All it does is put in those two 45-day windows. Deadlines are good. Let me just say that. This bill was filed in, late December, early January, had a hearing, I think, in January. At the time, some of the providers indicated, gee, we have some concern with that time window. We'd like it to be larger. And I said many times, come talk to me anytime. So this hearing gets scheduled, and lo and behold, finally, months later, get a call from the provider saying, hey, we'd like to talk. So having a deadline is a good idea because otherwise things just drag on and on and on and on. After discussions with the providers, it was said earlier, by the way, by the introductory remarks by the senator's aide, that agreement had been reached by both sides. I think that that's not accurate. Both sides have been talking. The carriers and the self-insured groups are willing to extend those windows out to be 90 days from the time of payment for notification of the carrier that the provider disagrees with it, and then 90 days to negotiate. So basically doubling each of those windows. And in talking with the carriers, there may be instances on complex claims where things need to go on longer, and we would support even providing, if both sides agree, an extra 90 days. If negotiations are going well and they need more time, if both sides agree they need more time, be willing to extend that out another 90 days beyond that. So we're talking at this point, 2 90-day windows, that's 180 days, plus an optional extra 90, that's 270 days. That should be more than enough time to bring resolution to these issues. And again, not have us going back 3 years and trying to find money that was already given back to our members. I do have, and I'll pass it out, some language that you might want to consider if you decide to go the route of adding an extra period at the end, an optional period. If I can pass that along both sides. In discussing with the self-insured groups, we're comfortable with anything that puts it into place some kind of a reasonable window, which we feel the 90 and 90 is reasonable. But as a concession to the providers, we'd be willing to add another 90. Again, if both sides agree, I think it requires both sides to come to an agreement that, okay, we need more time. Otherwise, things will just drag on and on. So thank you for listening. Sorry it took so long, and happy to answer any questions that may come up.
Thank you so much, sir. Representative Flanagan, do you have a question?
Thank you, Mr. Chairman. Yes, I do. Logistically, so Mr. Vallis discovers there's an error in his bills, and he sends another bill to the insurance companies. Now he's got unlimited money. By the way, thank you for the T-shirt. Before he had unlimited time to request additional funds. If this bill passes, he will, or if my amendment passes, he'll have 90 days to argue that. And then if there's the way it's written, another 90 to try to negotiate. So it's really 6 months to negotiate. And then at that point in time, it goes to the commissioner for their decision.
If the provider chooses to appeal the commissioner, yes.
Correct. Follow up?
Please.
So you're adding another piece that says if you want to go longer after the second 90, that you can go longer. It sounds defeating the purpose, Senator.
Thank you for the question. As a concession to providers' concerns, we're willing to do that. We're obviously comfortable with the original or your amendment for 90 and 90.
And then go to the labor. Okay.
We're comfortable with either one.
Representative Granger.
Thank you, Mr. Chair. Is it safe to say that the healthcare providers want the limit to be as long as possible and insurers want it to be as short as possible?
Thank you for the question. I don't know that I would characterize, I won't speak for the providers, but certainly from the carrier's perspective, I think as short as possible may not be the best, the public policy wise, because as short as possible would be you have, 24 hours to dispute, right? So I think there's a reasonable time where both sides' interests are protected.
Thank you.
And Representative Cahill.
Thank you, Mr. Chair, and thank you, Senator Bragdon. Am I correct in thinking that if we double it to the 290s and the parties agree that they need more time, there's nothing to prevent them from talking longer. It's just that the providers would not go to the commissioner and seek of his ruling.
I'm sorry, I kind of missed the first part of that. Could you say that
Let me
again,
try
please?
again. Okay. So,
Please.
yep, okay. So we've given it the 90. We double it to 90 and 90.
Okay.
And yet they're still at an impasse.
Yep.
It's up to the provider at that point to decide whether or not they want to go to the commissioner or they think they should talk with you some more, talk with the carrier some more, and work it out. So do we really need to go with an extra 90 at the end of it if they're not compelled to go to the commissioner unless they're really not agreeing that, that there's time and effort that we should put into it.
Thank you for the question. I guess I would repeat what I said before. We're comfortable with either way, but felt it might give more comfort to the provider side.
Thank you.
Representative Sullivan, sir.
Thank you. Mr. Bragdon, would it be fair to say that if the provider and the carrier are engaged in active negotiations, but simply have not completed the process, there might be some value to that additional 90 days?
Thank you for the question. I would say that some would see some value in that, yes.
Thank you.
Okay.
Oh, okay. Follow up
Please,
this.
for a follow-up.
I'm not sure who this question is to, but I've heard talk about an amendment, and I heard one of our members indicate that he has an amendment. So do we actually have an amendment? Because we're talking about executing today.
Yeah, we do. Go ahead, Representative Flanagan.
Yes, I originally, to answer your question, yes, I had an amendment. Senator Bragdon contacted me and said the TPAs were concerned, they wanted more time. So this morning I got here early and went to OLS and put in one for 90 days. So it was 90. Jamie should have it in her inbox. She was going to have it for us during executive session to amend the bill during executive session. I don't know if that's within the policy realm.
Yes, sir.
This might be a little bit out of order, but seeing how we've got a time crunch, I'm willing to sponsor or co-sponsor the 90-90-90 version to provide that additional space for the carriers and providers to negotiate.
Representative Flanagan.
Yeah, I appreciate that from Representative Sullivan. I didn't include that other 90 for one reason and one reason only. Sometimes people will drag the thing out knowing that they can, but when it goes to the Department of Labor, all of a sudden, your trump cards are gone. Now you're at the mercy of somebody else. Sometimes you're better off getting what you can get in a settlement discussion and move on.
Okay, so what I would like to do is if we can get that amendment out to the committee prior to going to lunch, so we can look at it. And then we will discuss the amendment as written. If we want to further amend that to 90-90-90, we can discuss that in executive session.
Fair enough.
Okay? No, that's fine. Just, if she knows, she'll bring it in.
Well, I told her for exactly needed it, but if you want it now, I can ask her to print it out now.
Okay, that would be great. Thank you. Okay, thank you. Seeing no questions, thank you for your
Mr. Chairman, if I
testimony.
can add one thing, just a comment came up earlier about, how do you determine when something was sent and like details like that kind of in the weeds. I think the department through its rules can easily determine what they're going to use for definitions of that. So I don't think we need to bog down the legislation in that, but my
Okay.
opinion. Thank you.
Cool, thank you. Ms. White, please.
Good morning. My name is Jennifer White. I am the CEO for Concord Orthopedics. Concord Orthopedics has been in the community for over 50 years. As you can imagine, we see a large amount of workers' compensation patients due to the nature of our business. Our providers provide immediate access to all patients, specifically to workers' comp patients. We see those patients without valid information being on hand. Typically, a patient would come to our office with insurance information, but a workers' comp patient, we treat the importance of their injury because we're not only dealing with the patient, but we're also dealing with the employer, and we're actively working to remedy the situation and get that patient back to work as quickly as possible. We work very closely with the carriers. We have actually a very close relationship with the Lawson Group. I'm here to oppose this bill for a few reasons. One, claims don't actually pay in 30 days. I know that that is the ruling and that is the expectation, but that does not typically happen. Claims don't always pay properly when they are paid. Typically, more than 50% of the payments that we receive from workers' comp payers are not paid correctly, and we do have to go to the provider burden of appealing those claims. That process is a very arduous and timely process. We have to contact the adjusters. We do that via phone, email, fax, and request the claim to be reviewed. Many, many times, those adjusters don't respond to the email, don't respond to the fax, don't respond to the phone call, and it takes multiple opportunities for us to continue that communication just to have the conversation about why we feel the claim was not processed and paid accordingly. Our goal is to never go to a hearing. We want to be able to negotiate our payments outside of going to a hearing. When we go to a hearing, it is a very, very costly process for the provider to do that. And it's not something that we want to do. Oftentimes, we have to hire an attorney to represent us because that's not the business that we're in. Our business is in providing timely, quality health care to all patients. My opposition to the bill is really the time frame. What was stated earlier is that we only have 30 days with most insurance carriers to appeal a claim. That's actually a false statement. We have, for most carriers, 6 to 12 months to appeal claims. Patients that have workers' compensation have the right to appeal if their workers' compensation claim was denied. In other words, they weren't covered for workers' compensation and now they've been billed 18 months. That's the clarity of the question that you had asked earlier, is that the patient has the ability to appeal to get their workers' comp claims paid if they were actually denied coverage in the first place. As providers, the process to appeal underpaid and incorrectly paid claims is very, very timely. We would like to compromise on the time frame. We think that 12 to 18 months is reasonable. 18 months, because that's the time that patients are allowed to appeal workers' comp claims. 12 months, because that's the standard that most insurance carriers follow for appealing claims. I think one of the biggest things to really mention is that the burden of the amount of claims that will go to hearing will increase dramatically. We likely will not have the ability to come to a solution with the adjusters in the time periods that have been referenced. As a result, we'll have no choice but to go for a hearing, and we'll send those hearings in by claim versus what we do now is we send it in by episode. So we'll send it in for a patient's entire episode of care one time. But if a patient had 10 services rendered, we'll be forced to send those 10 claims in individually because we'll be up against a timely filing appeals process. I do think that there needs to be a time frame. I think that having no time frame is something that does need to be modified. I just think that it needs to be fair to both sides. And we have a very great relationship with the Lawson Group. They are probably the least concerned for us. There are so many adjusters and carriers that we have to work with that this law would apply to all of them. They don't all work the same way. In fact, some of them will send the same claim in and they'll pay it differently on 2 different patients based on who the adjuster is. So there's a lot of things behind the scenes that create a lot more work for the providers to simply get paid for the services that they're rendering. And that's why we feel that the time frame should be between the 12 and 18 month period process. I do recognize the amendment of the 90-90-90 without really reading that through and having a chance to understand what that is. My first reaction to that is that that's going to take it's a lot of moving pieces for us to know what day is the 90th day versus just having one time frame for the entire process. Thank you.
Representative Flanagan.
Thank you, Mr. Chairman, and thanks for testifying and coming out and taking your time to do it. I don't think I've ever filed a workers' comp claim, but I've always given sort of the analogy of when you smash up your car and they give you an estimate and you go get it fixed, but while they're fixing the car, they discovered, oh, wait a minute, we didn't realize there was a broken radiator or Schwab or whatever, so they bill the insurance company again, and then the insurance company comes back and says, all right, we'll pay that. Is that sort of what we're talking about here, is where you go back, or is it just a repeat visit addressing the same thing?
Sure, thank you for the question. So it's a bit different. So a patient will come in for a visit, right? At that visit, we haven't still figured out how to see through skin, so they'll typically have an X-ray,
Yep.
right?
Yep. Or
That-
an MRI.
Or an MRI, right? That bill will then be sent out to the carrier. That patient then starts a treatment plan. They may need an MRI because the X-ray wasn't able to tell us exactly what's going on. So now the patient will come in for another visit. They'll have an MRI. Based on the results of that MRI, that patient may need an additional treatment. Let's say they need surgery. So now they'll come in for another visit, they'll have surgery. And then through surgery, they'll have follow-up care until they recover and they're able to return back to work. So that's why there could be multiple dates of service
Okay.
and
Go ahead,
visits
sorry.
dates of service for a patient. So it's not, the patient typically with an orthopedic injury doesn't come in one time and there's nothing wrong. Typically they come in, they've had an injury, they have to be evaluated. We have to use the X-ray to evaluate the patient, and then we determine the treatment plan for that patient. So that's why there's multiple claims.
Okay.
The episode would be from the beginning date of injury, the first visit, through the recovery period.
Okay.
And depending on what the injury is, it could be a few claims, or if it's a surgical claim, be to the 90th day after surgery.
Follow-up?
For follow-up, yes.
Thank you, Mr. Chairman. So these are ongoing bills.
Correct.
Should they not be paid as ongoing bills?
They are paid as ongoing bills.
Okay, so what are we trying to address here then? Something that didn't get billed, or you forgot about the MRI and now you're sending it out later?
No. So what I was stating is that when we send in an appeal, so once the claims are paid, and to be honest, typically the office visits are paid well, and we don't have to go through further negotiations with the office
Right.
visits. It's typically for our practice when the patient gets to the surgical portion of their care where we aren't paid according to what we feel is a fair rate, and that's when we have to go to the appeals process.
Oh, so they're disputing, just clarification.
For clarification, yes, sir.
Thank you. So they're disputing how much you charge it.
Correct.
And Representative Sullivan.
You mentioned 12 or 18 months. Let's settle on 12 for a moment.
Sure.
Exactly what would happen during those 12 months, and what would happen when those 12 months are up?
Sure. So during the 12 months, for any claim that the provider feels has not been paid at an acceptable rate, we would have the ability to work with the adjusters and go through the burden of doing a negotiation for payment. And should we not have the ability to come up with an acceptable rate of payment by going through that process, then we would have the ability to go to the Department of Labor and have a hearing during that time period.
Oh,
Yes, sir, for a follow-up, please.
so are you saying the hearing would take place during the 12 months or after the
can't-
12 months?
We can't control when the hearing would take place. So I don't know if I could answer that question. So once we determine after we've worked with the adjuster that we're not able to settle that claim, we request that hearing immediately. If the adjuster responds timely and say in 30 days, we don't have the ability to come to an agreement, we would go to we would request that hearing immediately. If they're trying to work with us, sometimes that takes several months. We would follow the process of going to a hearing. We only go to a hearing once we're unable to have both parties, the provider side and the adjuster side, come to an agreement in terms of what the final payment would be.
One more.
Yes, please.
It seems to me that the whole reason that this has come up is because things don't happen immediately.
Correct.
But you say that
They don't, yes.
I guess I'm still confused, but again, it hasn't been put together clearly as a process, so I'll leave it at that.
Okay. I gotcha. Any other, yes, Representative McKenzie.
If I could, the way my brain works, put this in the context of labor relations. So you have a final appeal to the, well, it's not a final appeal, but you have an appeal and you go to a hearing.
Mhm.
Is there a role for mediation in the interim that would require both parties to basically submit to mediation, and that there be a structured mediation process, so that people would be required to meet certain deadlines, timelines, and that the mediator would be responsible for trying to make that settlement, as opposed to having two parties kind of bang it out.
I would probably let someone behind me who's an expert in that process answer that a little bit better. But I think that's the goal of the appeals process after we receive payment and before we go to the Department of Labor hearing, that both parties are trying actively to come to an agreement on an acceptable payment amount.
Okay, and if I could.
For a follow-up, sir?
So the idea of a facilitator that helps that process, and we can't probably do that in this context, but that's the only thing I'm wondering about. Thank you.
Representative Cahill, go ahead.
Thank you, Mr. Chair, and thank you for taking my question. We were talking about 6 months, and you're interested in a year. Do I hear 9 months? Like with 135 days, for each of those portions?
I mean, I certainly wouldn't be able to be the only one to weigh in on that, but I would think that it would be much more reasonable than the current amendment.
Thank you.
Okay, ma'am, thank you.
Thank
We
you.
really appreciate you coming over and taking the time.
Thank you.
And if I could call Ms. Karen Mortisey? Matthew, gotcha, sorry.
The first thing I'm going to do is I'm going to submit 18 of our positions, and then I'll test them all. My name is Karen Mackey. I work for New Hampshire Orthopedic Center and have done so for 20 years. I work as the Director of Clinical Operations and the manager of the Workers' Comp team. I have 4 employees under me, and that what we do is soup to nuts, clinical to billing. I'm here to talk a little bit more about what actually happens. It's very good that this conversation is happening, but we're having a conversation about self-insured that is only 5% of the population of our workers' comp carriers. We treat 14,608 workers' comp visits, and that is 19% of our patient volume. We're talking a very huge impact it would have on our organization. So at this point in time, I have lived my life in New Hampshire, and I support the self-insured. As a workers' comp provider, we have treated all of the self-insured very well. The issue we have at hand are the larger carriers that are not in the state and don't have knowledge of our processes. Some of the things that Jen White was talking about in regards to getting paid, we submit a bill. Sometimes we get paid in 30 days, sometimes it's 6 months. There's a lot of communication that has to go. I have one person that works that process. You mentioned maybe somebody would be helpful to actually, in that 90 days, get them together. I'm going to be honest, that's probably an excellent idea. 9 times out of 10, right now I have $106,000 in hearing right now going to be heard at the Department of Labor for low pay. None of them are the self-insured. All of them are the larger companies. So the issue that I have at hand is that we're making legislation for the whole population when we're only talking about 5%. At this point in time, there also was the switch. Many people have talked about the switch of the provider now has a burden of proof because of the RSA that had changed in 2024, I believe. That has changed the process. Has it been harder on the providers? Absolutely. It was much nicer when the money flowed in, we didn't have to address it, and we had contracts that would make the process easier. That doesn't happen any longer. Many of the insurance companies, the larger insurance companies, use repricers to send our bills out to look and at Are they reasonable? Are they reasonable per whose standards? California standards, New York standards, but not New Hampshire standards. And that's really where it comes into play when I actually am requesting a hearing. We've already gone to the point where we've had the adjuster not answering us, not lost the 1,500, I haven't heard from you with the checks in the mail. All of those things we hear. But it takes a lot of time. For the $106,000 that I now have in hearings that is coming up, it probably took my team at least 8 months to get to the point that I had documentation enough that I felt comfortable bringing it to the commission. It takes time to do that, to put our ducks in the row to get that done. I've outlined some of my concerns. One of the things that I wanted to speak about is there was some discussion in that the cost may be somewhere around $10,000. I want to tell you that that's not true. From a provider standpoint, we're a private practice. We have 18 providers, and right now I would run the risk of having to possibly adjust off $750,000 that sits in our 140 to 190 day AR bucket. So at this point in time, I'm saying that should show you also that it's not easy to collect money in the comp realm. It takes a lot of time. I do think that I would like just to have a pause. I think we're looking at trying to put something in play with not enough investigation. I respect the fact that the self-insured bucket needs timely, and it does really create an issue for them, but it also, we have to take into account the whole picture in the insurance industry, not just the self-insured. And this would, if you enact this, would also tie our hands. And something that Jen mentioned, we would be here for every visit. I wouldn't be doing an episode of care for hearing. So I have to say, I would like to see us pause, take a minute, have more of a discussion, and see what would be good for all sides.
Thank you for your testimony. I appreciate your passion. Representative Granger.
Thank you, Mr. Chair. Is 6 months too short?
It is for the other insurance carriers, absolutely.
Thank you.
Okay. Any other questions or comments? Thank you, ma'am. I appreciate you. Representative Flanagan, one question, please.
Yeah,
Thanks.
absolutely. So if I understand this correctly, is the insurance companies don't want to pay what you're charging? That's pretty much what 90% of the
correct.
issues?
Yes.
Okay, good. Thank you, ma'am. I appreciate you coming
As
over.
I mentioned, we don't have that problem with the self-insured in the state of New Hampshire. You talk about the larger companies that are not based in New Hampshire, that's when we have the issues.
By the way, you can tell the doctor who called me that I didn't.
Okay, good. And Ms. Herbert, please, or Abear.
Good morning. Is it morning, afternoon? So my name's Chris Hebert. Good morning. I am the manager of the business office at Concord Orthopedics. So I have, I'm not going to repeat a lot of what you guys have already heard from both Karen and Jen. But what I can say is that I've been doing my role as a manager for Concord Orthopedics for over 25 years and seen a lot of changes in the healthcare industry over those 25 years, and workers' comp being an area certainly that every day becomes a little bit harder every day to allow my providers to, there's more work that's involved in getting my providers payment for the services that they've provided to every patient, not just workers' comp. In terms of workers' comp, as Jen said, we see those patients. Those patients present to our office, we treat them. But every time I have to send a patient claim to the Department of Labor, we potentially are losing money in the treatment of that patient. These payments that we're talking about where a workers' comp carrier underpays that we're negotiating, sometimes they're paying us less or at the same level as a Medicare patient. And those patients, Medicare gives a whole lot of different avenues for us to get paid timely. Electronic claims, limited appeals, rebilling things, and it's much more seamless. Workers' comp is pretty much 100% manual. So it already costs us more to take care of those patients on an administrative side. Adding any additional layers to that process is going to just increase the cost that it takes our practice to render care to those patients. So anytime I have to dispute a claim, go before the Department of Labor, then I am risking my provider not getting paid appropriately for the service that they provided. So what happens when that happens? So we have insurance carriers, non-workers comp, that we don't believe that we are paid well, and we make a decision to not treat those patients that have that insurance. And that is not what we want to do with workers' comp. But anytime there's a process, I'll be fair. So there's a negotiation process. It's reasonable, for them to say, this is the cost of care. There's a lot of processes that are in place. But every time you add barriers to care, you add administrative burdens, the providers then say, you know what, is it worth the time that I have to expend to treat those patients? And it becomes a hardship to the practice. And what would happen is we would have to negotiate each claim up front. And what would that do? That potentially would delay patient care. So that would prevent that patient from getting in, come right in, we'll treat you. Absolutely, we want to do that. But if we have to worry about that reimbursement piece, then we'll have to negotiate that up front. And then what will happen is there may be patients that have a delay with their appointment. They may not get seen right away, which would keep them out of work potentially longer if they're workers' comp patients. And that's certainly not what we want to do. All of those layers they just prevent additional administrative work that I feel like we should be working together to how do we reduce the administrative work that's involved in treating our patients. I can say that as of this morning, I already have over 110 claims that I am working on from January alone that have not been paid at an acceptable rate to us. And that if I were to have to go before the workers' comp hearing boards for those claims, that would inundate the Department of Labor. And without having a reasonable time frame in place, which I believe a reasonable time frame would be anywhere between 12 and 18 months to dispute these claims, that we would inundate the Department of Labor. The Department of Labor would not be able to handle all of the hearing requests that would be coming forth. And that's just going to be a problem. And then there's the self-insured are not going to be able to close their books because those claims aren't going to be resolved. They're going to be still sitting there. You could be looking at 12 or 18 months that you're waiting for a Department of Labor hearing just based on the volume alone. So my position is that I am in dispute of this bill as written and would recommend a 12 or 18 month filing limit for that Department of Labor hearing.
Okay, thank you. Representative Granger?
Thank you. Correct me if I'm wrong. So you work for a healthcare provider, correct?
Yes.
Do you guys publish your rates for services?
They are available upon request. We're obligated to provide estimates to patients for their out-of-pocket, but our rates are not published on our website.
Follow up?
For follow-up?
How would I get those?
Yep, I can give you my contact information and I can provide that to you.
Thank you.
Yep.
Okay, thank you. Representative Staub?
Thank you, Mr. Chair. We have been throwing out random numbers of days. What is a reasonable time frame for an episode of treatment? How long typically from the first visit until, they complete physical therapy? I mean,
it really varies. Yeah, it really varies. We have patients who come in and they have carpal tunnel and they just need one appointment and they're not surgical candidates. They're seen once and given a brace and they do well and they return to full duty. We have patients who hurt their back and they are 100% disabled and continue to treat ongoing. So we have, different surgical procedures have different follow-up periods. So it really is, it's 100% dependent on the individual patient situation.
For follow-up, yes, ma'am.
Yeah. So one of the things that several of you have said is that you don't want to have to file individual claims all
Correct.
the time. So if we could come up with a time period where you could kind of bundle the claims together, what would be a reasonable time for doing that?
I would think 6 months.
Thank you.
Okay. Any other questions? Representative Sullivan?
It's been testified more than once that insurance companies are not paying within 30 days. What percentage of bills don't come in within that time frame?
I would say at least half. And it could be even higher than that, probably. I would say because the carriers have 30 days upon receipt of the claim. And so there are many times where the claims are not received. We don't receive any payment and they don't have the claim on file and we have to rebill. So it's greater than 50%.
Oh,
Yes, please.
it occurs to me that perhaps the reason why they're not getting to you within 30 days is because you send them a bill for what you think it's the services are worth. They send you a check for what they've decided the services are worth. Is it possible that it takes more than 30 days for them to figure out how much they're going to actually give you?
Could certainly be part of it.
Thank you.
Representative McKenzie?
Thank you, Mr. Chairman. So it seems to me that this chaotic period that occurs once the claim is filed, and then there's carriers that are out there that are pretty much doing, they have a certain way that they approach this, and they put you at a disadvantage. And there is nothing to compel the employer to come to the table. So you could, the carrier, to come to the table. What the concept of mediation that I raised before, do you think that has any value in this process where they would be compelled to come to the table at a defined period of time?
I would like to believe so. What I can say is that unfortunately it takes many times where you have to go through the work of filing a hearing before the Department of Labor before you get their attention. And it's at that point when they will actively start negotiating with you. So you have to go through that process, unfortunately. But if it was required, that was a required step, then I think that there is a good opportunity for that to be beneficial.
And for a follow-up?
And so, if it was mediation, you would tell me how you think that might help you in discerning this and then coming to some kind of summary that would eventually maybe go to the Department of Labor for a hearing.
I think that it would be helpful because it would be somebody, well, I think it's, as Karen had indicated, a lot of the carriers they use different repricers to determine what they feel is fair and reasonable. So there's a lot of different opinions about what is fair and reasonable. It's certainly open for a whole lot of different opinions for that. So I think anytime that you have somebody, a third party who can act as a mediator to try to resolve some of this, and it may be some of the higher dollar claims, maybe that's the opportunity for that, is that those high dollar claims that really make up the majority of our accounts receivable that are outstanding. I don't think it would be, I think in the goal of trying to avoid Department of Labor hearings and burdening that system as well, I think that it's a good opportunity to try something different to help us.
Okay. Thank you, ma'am. I appreciate you taking the time to come over. Did you have a question? Please.
Do you happen to know if other states have a number for this?
I'm sorry, to have
For the waiting for how long before the claim can be challenged?
I don't know the answer to that question.
Thank you.
All right, ma'am, thank you for taking the time to come over. Appreciate your testimony. And Miss Albert, floor is yours.
Good morning, everyone. I'm Danielle Albert. I'm the Deputy Commissioner of the New Hampshire Department of Labor. The department has reviewed the language of SB 67. We are neutral on the bill. I did want to perhaps, and trying not to be duplicative of testimony that's already been provided, just try to crystallize what the disputes that the disputes that are at issue for which the amended language are going to be affecting. And it is those disputes where a provider has generated a bill for medical services rendered that's been presented to the insurance carrier. They do have 30 days under the workers' compensation statute to make payment. To do one of two things, honestly. The insurance carrier reviews that bill and whatever they need to look at to make a determination about whether or not they think they're liable for it. If they determine, yep, voluntarily we are liable for payment of this medical expense, they have to issue payment. If they determine that they're not liable, they have to issue a written denial, which the injured worker can then challenge. When issuing that payment, so the insurance carrier is accepting liability for the medical service that's been rendered, Section 24, which this language is proposing to amend, authorizes or allows the insurance carrier to pay what they determine to be the reasonable value of that service. So these reasonable value service disputes are in relation to the insurance carrier not paying the full balance of the bill presented. So these are the disputes that we're talking about. The language that's been proposed is adding some additional requirements to the statute that the healthcare providers are required to go through in order to exercise their option to go to a hearing at the department. Under current iteration of the statute, if what a provider has to demonstrate in order to have a hearing is that they've made attempts to resolve the dispute. And the department, in looking at scheduling those hearings, looks for things like, did you attach a demand letter of some sort, or give a list of telephone calls, or attach emails, or whatever it is that they have to demonstrate that they've tried to resolve that dispute. Through this additional language, there's now certain notification periods that the provider would also have to put forward in order to exercise their option to go to a hearing. And the department's understanding and interpretation of this language is if those requirements are not met, the provider is barred from having a hearing. I'm familiar, Senator Bragdon was quite kind and gave the department notice this morning about the amendments or proposed amendments to the timeframes. I've not looked at that language in detail. Under the original language, the provider has to notify the employer or the employer's insurance carrier, whichever one is applicable, no more than 45 days after receiving that payment about their dispute. And then no more than 45 days after that notification has issued, they have to ask for a hearing. So when we're talking about these time frames, whether it's the 45 or 90, whatever the committee determines is appropriate, if that language remains as drafted, it could arguably be less than the full amount, dependent upon when the notification issues. So if, in the original language, the healthcare provider provides the notice to the insurance carrier on day 30, from that 30th day, the second 45-day window starts to click. So I just wanted to highlight that the department's interpretation of the language as written is it's not a full 90 days. It really depends on when that initial notice goes out, because that second 45-day period is going to be contingent upon when that initial notification to the insurance carrier about the dispute goes out. So it could arguably be something that's less than 90 days. If that language were to remain similar, but we change 45 to some other time period, I think the application would still be the same. So if the intent is to give a block set of time, we would suggest thought or an eye towards tailoring that language such that the full amount is given. The department further understands this language to mean that if those requirements are not met, meaning that the notification was not provided and then the hearing was not requested within that allotted time frame, again, there would be a bar and the provider would not be able to exercise their option to go to a hearing. So that's our understanding of the language. There has been some testimony about would it cause an increase in hearings at the department. I think that's possible. I don't know that the department has a way to realistically or credibly quantify what that could potentially look like. I would defer to the providers on how, in their testimony, and how they would intend to handle the situation if this language went through, but it certainly is conceivable that the department could see an increase in hearings. Again, we just wouldn't know how to quantify what that amount would look like. And with that, I'm happy to take any questions if there are any.
Representative Sullivan.
Thank you, and thank you for taking the question. I have to say this all reminds me in my labor relations days of processing grievances, where if you miss the deadline, you're dead in the water, which is kind of the way it sounds here. With that said, it was testified again multiple times that payment is not made within 30 days. That doesn't leave anybody dead in the water. They're just waiting for their payment. Is there any enforcement mechanism for that? And if so, how does it work and how often is it applied?
Yes, thank you very much. That's an excellent question. There is an enforcement mechanism built into the workers' compensation statute for when an insurance carrier fails to take the required action within 30 days. If you are interested in the reference, it's set forth at RSA 281A23, which is the section of statute that outlines and dictates the insurance carrier's responsibilities for making payment of reasonable, necessary, and causally related medical expenses. So under that section of the statute, if a bill is presented to an insurance carrier, it triggers a 30-day time frame for that insurance carrier to review the bill and pay or deny. If the insurance carrier fails to take any one of those two actions within the required 30-day time frame, the statute goes on to set forth a monetary penalty, a civil penalty for failure to abide by the requirements in the workers' compensation statute. The penalty is an amount in an amount of up to $2,500. So as to how often does the department encounter that? I think it's important to note insurance carriers are not required by law to notify the department when they make payment of a expense. If they've determined they're liable for something, they're simply required to pay the provider. They are required to notify the department when they deny. So we only have record of denials. More often than not, issues with either non-response or something being beyond the 30-day time frame come to us through complaints from injured workers or their counsel, and occasionally from medical providers. In those instances, the department initiates compliance outreach to try to resolve the issue, and then it's reviewed for appropriateness for administrative penalty by the division, the workers' compensation division director. I don't have firm numbers on how often that comes up. I'm comfortable saying that it's an issue that does get presented to the workers' compensation division often enough that we have conversations about it.
For follow-up, yes, sir.
Is it your impression that many of these late payments don't result in any interaction with the department?
It's possible. If we don't have interaction and no one's notified us about it, we don't know that it's happening. So it's possible. We only know about the instances where payment has not been made or is delayed when somebody notifies us that it's occurring.
Thank you.
All right, and Representative Granger?
Thank you, Mr. Chair. Do you happen to know what other states do for this?
That's also an excellent question, and I do not necessarily. I know there are states out there that utilize fee schedules, but as to whether or not the other 49 states have similar mechanisms for reasonable value disputes, I'm simply not familiar. We're happy to try to take a look if that's something that you're interested in.
Thank you.
And Representative Flanagan?
Thank you, Mr. Chairman. Back to basics. A business is protected for injury of their workers through the workers' comp policy. And the insurance company is required to pay the claim instead of the employee or the employer. So all of these people here generate bills for their services, and the insurance companies refuse to pay the amount that they're sending. And I don't know if there's and I'm getting there, just give me a second. I don't know whether there's a generic fee for orthopedics or whatever. But the point being is there anything stopping the doctors from suing the insurance companies?
That is a very good question.
We're full of them today,
Yeah, all the good questions come from the Labor Committee, which I highly appreciate. I will say there is not a mechanism in the workers' compensation statute that specifically authorizes that type of action from a provider. The workers' compensation statute itself confers original jurisdiction on the Department of Labor to resolve these disputes. So I could see that potentially as being problematic in a provider trying to pursue a claim to, for the balance of that bill outside of the department.
Right.
Whether or not there are other statutes or laws out there that alter that analysis, that would be outside my area of expertise.
Follow-up?
For follow-up, yes, sir.
Statute of limitations in the state of non-contractual agreements are a year,
Mhm.
and it's 3 years for in writing. Do these physicians, medical people, would that also fall under the law as far as their ability to go? In other words, if there's nothing written between the insurance companies, do they have a limit on 1 year to pursue it, period?
Also a very good question. So the way that the department has viewed the timeframes in which these individuals or all these entities have to pursue disputes, again, under the guise of 281A, the workers' compensation law, is the 18-month timeframe that's set at 42D.
Finally, Mr. Chairman.
Yes, sir.
I don't know how other people's, but I think this bill might need to be retained
We'll discuss that later.
in executive session, I know.
Representative McKenzie.
The question I have is, I heard that some of the carriers, some of the providers are concerned or won't take claimants who go to certain, the insurance carriers won't pay for it. So they don't want them. They basically send them out. How does that, if the law allows the employee to go, the injured worker, to go to the place that they think they get the best care? Now, what we heard is that because of the system that's currently in place, that they may not have access to the best care. So is that a conflict in the law? Does this business model disadvantage injured workers?
That is also a good question. As far as one, the workers' compensation statute itself doesn't set a specific requirement that any kind of provider has to take on a workers' compensation patient or keep one. So there's nothing in there about that. There is a section in the statute that makes clear that injured workers have the right to treat with a provider of their choosing. That's also set forth at section 23. Whether or not there's a disincentive there and it makes sense or it's a problem, I would defer to the committee in determining sort of policy-wise, does that make sense for the system? I will note from the department's perspective, I'm not aware of wholesale complaints coming to the department where it has been indicated or relayed to the department that a particular provider or series of providers are not willing to treat injured workers because of reasonable value disputes. That does not mean that does not occur. It just isn't being brought to the department. We occasionally will hear something about it in the context of pre-approvals, which is a separate process. But again, that's very rare that it's brought directly to our attention.
Okay. Seeing no further questions, thank you again for your clarification, your concise testimony. Having no more testimony on the schedule, I hereby close the testimony on SB 67. And I open the testimony on HB 169. And to introduce the bill, we have Mr. O'Neill for Senator Rosenwald. And Mr. O'Neill, are you here? Is there anyone here to open the testimony on HB 169? Correction, SB 169. Yeah, go ahead. And I hereby authorize, are you Mr. O'Neill? Okay, good afternoon. Come on in. We're running a little bit late, but thank you for your patience. And you're here to introduce SB 169? Beautiful.
All right, thank you. For the record, my name is Tommy O'Neill. I'm the Minority Caucus Director, and I'm here to introduce SB 169 on behalf of Senator Rosenwald. This bill will provide more information to individuals receiving workers' comp benefits. Workers' comp benefits are weekly payments paid pursuant to RSA 281A by an employer's insurance carrier, which are intended to replace some portion of the lost wages of employees who have a work-related injury or illness. Typically, this is approximately 60% of an employee's regular wages. Sometimes the employer pays more. When members receive their workers' comp benefits, the amount they receive typically includes a duplication of payment of wages, which the employer had been paying on a contingent basis. The employee subsequently owes this amount back to the employer. Additionally, in many cases, the employer continues to pay both the employer and employee cost of voluntary withholdings or deductions, the employee portion of which is eventually owed back to the employer by the employee. Employees who are out on workers' comp for extended periods of time often receive minimal communication from their employer. When they return, they are notified that they owe some amount, sometimes a significant amount. An employee may have failed to plan for due to lack of understanding or education on the subject. In one instance of note in Portsmouth, an employee returned to work and they were told they owed the city over $18,000. This bill aims to eliminate these surprise owed payments by creating a system based on transparency and routine communication between the employer and employee so the employee can plan. An important note, this bill does not shift any employee costs to any other party. It simply notifies them what they are anticipated to owe and a method to pay the amount back. I hope the committee will look favorably on this bill, and thank you. And I can attempt to answer any questions, but I think there are some people behind me who would be better served.
Okay, thank you for introducing the bill. Are there any questions from the committee? Seeing no questions, thank you so much. Appreciate you coming. I'd like to now call Mr. Govia. And your testimony is in support of this bill?
Yes.
Okay.
Mr. Chairman, members of the committee, for the record, Tyler Govea, Director of Government and Political Affairs for the Professional Firefighters, New Hampshire. I sit before you today in full support of SB 169, which seeks to provide greater transparency and financial certainty for employees receiving workers' compensation indemnity benefits. Workers' compensation is a critical safety net for employees who suffer work-related injuries and illness, ensuring that they receive a portion of their wages while they recover. However, the current system often leaves injured workers in the dark about the financial obligations, leading to unexpected and sometimes significant repayment demands upon their return to work. This bill addresses the problem by requiring employers who provide supplemental pay to issue timely and clear breakdowns of payments, anticipated financial adjustments, and method of repayment. Under the existing system, many employers supplement indemnity benefits with additional pay based on personnel policies or collective bargaining agreements. This supplemental pay is intended to help injured employees maintain financial stability. However, in many cases, the employer continues to cover both the employer and employee portions of voluntary withholdings and deductions, and in some cases covers the employee's full wage until such time where there's a ruling in their workers' compensation claim. This can result in the employees unknowingly accumulating debt, and that is debt that they will have to repay upon returning to work with little or no warning. We heard of the example, which was one of the examples we gave to Senator Rosenwald when we talked about bringing this legislation forward, was the firefighter in Portsmouth who came back after some time out and was handed a bill for $18,000. Should this legislation have been in play, this member would have been able, while he was out, to know how much he was going to owe, allowing him to properly budget and come back without having that more undue or that burden stress. SB 169 provides a common sense solution by mandating a routine employer-employee communication regarding the financial adjustment. Specifically, it requires employers who provide supplemental pay to an employee to issue a breakdown of payment and anticipated financial obligation within 30 days of an employee's injury, and every 30 days thereafter. This ensures the employees are fully informed on their financial obligation and can plan accordingly, reducing the likelihood of surprise repayment demands upon their return to work. The one thing I do want to be very clear about here is there's no shifting of costs that happens in this bill. I can't stress it enough. The legislation does not shift any financial burden from the employees to any other entity. All it does is simply tells the employee how much they owe and how to pay it, so there's no surprises at the end of the day. On behalf of the professional firefighters of New Hampshire, I please ask for your support on this legislation, and I am happy to answer any questions the committee might have, and if I can't get them to you, I am more than happy to get answers for you guys before your executive session this afternoon.
Representative Cahill, sir.
Thank you, Mr. Chair, and thank you for taking my question. Could you give me some sort of an overview of what sort of expenses can be clawed back? Are we talking about the health insurance premiums that would be paid, or vacation time, salary? What are we talking about as far as benefits that will be taken back? Is it 60% of the other of what they were receiving? I just want to know what we're talking about here as far as what the employee should plan on, and does it vary from one place to another?
Well, I would absolutely say it varies from where you are, and these withholdings would be really, as I stated in the testimony, based upon the collective bargaining agreement or personnel policies. So it's kind of hard to pinpoint based on one situation, but everybody would be a little bit different. It wouldn't be a clear-cut kind of equation.
For a follow-up, sir.
Is there sort of a general purpose, guide, or is it just anything's possible?
I wouldn't want to speculate on that. I can try to get you some more clear-cut answers after this hearing for the executive session if you would like, though.
Representative Sullivan.
Yeah, I have to say that I'm surprised the direction this has taken. I didn't anticipate repayments as part of this in reading the bill. And I'm wondering if the repayment might occur because under, say, a collective bargaining agreement, it says that if someone is on workers' comp, they will receive the workers' comp benefits. In addition, the employer will pay perhaps the difference between workers' comp and their full pay. I wonder if the repayment issue arises when the workers' comp claim is denied, so they actually aren't on workers' comp, but the employer has been treated them as if they were on workers' comp all along. Is that it? And if you're not sure, that works too.
I would be more than happy to get that answer for you, Representative.
Thank you.
Representative Flanagan.
Can you give me an example of supplemental income?
Sure. So I know we've heard stuff such as retirement. Off the top of my head, retirement comes to the big one coming to mind would be the employee portion.
But if they're retired, then they're not working.
These aren't retired. These would be people on workers' compensation.
You can, okay, I'll defer to.
Yes, please.
Foley.
Sorry, Representative, thank you very much. Having been on workers' comp and injury, I was required to pay back my share of my insurance costs and my retirement and my vacation and my sick time while I was out because it's only 60%. So I was also unaware and in a limited amount of time to pay back this large amount.
Thank you for that clarification. Appreciate that. And so just to completely understand, so you go on workers' comp, your employee recognizes that you're on workers' comp, but still pays you, as the representative clearly stated, certain things, and then the employer is authorized to get those payments back.
Correct.
This bill doesn't change that.
No.
All it does is say, we're paying you this, you're going to owe it back. I don't know why you wouldn't just stop paying it, but at the end of the day, though, if that happens, at least the employee knows this is a bill that's coming.
Correct, Mr. Chairman, and that's exactly what it does. Is you would get a bill every 30 days with those estimated deductions and what they would be. That way, you could go, okay, I need to set aside X amount to repay this. So when I get back, I'm not just stuck with like we said in Portsmouth, an $18,000 bill.
Okay, just out of curiosity, if I'm the employer, why don't I just stop paying those things and then it doesn't occur? Okay, that's not the question we're at. I'm just trying to figure it out. But at the end of the day, if I'm the employee, if I'm you, go ahead.
I'm sorry. If I'm still employed by you, all right, you still have to contribute to my retirement plan. I still accrue vacation and I still accrue sick time, technically.
Okay, and so then you just got to owe it back because you
But I
weren't
still
there.
have to pay that if I didn't work for you.
Okay,
I didn't provide work product for you at that time. You still have to carry me along until I'm not injured anymore.
okay. All right, I understand what's going on. Thank you.
Of course.
Any other questions? Representative Labrie.
Thank you, Mr. Chair. Real quick, this is for public and private sectors, right? This is for everything, or is this just for public?
I would want to check on that. I believe it is everybody, but I can
Just
double
being
check
from
on that.
the fire
Yep.
service, I was unclear. Thank you.
Okay, thank you for your testimony. And is this on 169? This pink card? It is. Would you like? Is that you? Come on up. Thank you.
I just wanted to clarify. So I'm Allison with Blue Lion, an HR consulting company. I just want to clarify so everyone understood the conversation that was just happening. When you're out on workers' comp is paying you wages. When you're employed, you get paid a paycheck. When you get your paycheck, you have your portion of your medical insurance taken out, your portion of dental, your portion that you're contributing to your 401k. So the amounts that they were just talking about that you're owing back is your portion of those benefits. So they can't stop you from being on health insurance, but let's say the employer pays $200 a week for your insurance and you pay $1. They keep you enrolled while you're on workers' comp, but they're paying $300. They have no paycheck to take that $100 out of. So when you get back to work, they're like, hey, you owe me the $400 for the month you were out because I kept you on medical insurance in case something else
Beautiful.
happened not work related.
Beautiful. Okay. Thank you, ma'am.
Any questions?
In 30 seconds or less, you're awesome. Flanagan, please.
So you're making 60% of your income,
Yes.
but you're still expected to pay all of those other ancillary benefits that come with the job. So now.
So the benefit that comes with the job is the ability to have health insurance.
Correct.
The benefit is not necessarily 100% paid health insurance. So I would also argue that it's not the employer's responsibility because you got injured at work that I now have to consume the cost of your portion of benefits.
No, I completely understand that, but the reality is that say you get hurt.
Yeah.
You're making less money than you
Accurate.
were when you were taking those benefits out.
Correct.
That's a little bit hardship, is it not?
Yes. Not disagreeing.
Okay.
But as an employer, I would not want to pay that bill either. Because I'm
Okay.
also, as an employer, have the hardship of you not being there. Yeah.
Representative Cahill, sir.
Thank you, Mr. Chair, and thank you, Ms. Milano. Do you think it might be a good idea for us to consider raising the 60% to something like 66 2/3?
No.
No.
Okay, let's keep it germane to the bill.
Well, we're talking workers' comp.
Let's keep it germane to the bill, and then we'll move forward.
Okay.
I can
Okay?
answer it in one sentence. No, because the more money that you're providing, the less likely they are to return to work, which is ultimately the goal.
Thank you.
Cool. Thank you. All right. Ms. Albert, ma'am, over to you again.
Good afternoon. I'm Danielle Albert. I'm the Deputy Commissioner of the New Hampshire Department of Labor. The department has reviewed the language in Senate Bill 169. We are neutral on the bill. To kind of springboard off of some of the testimony that's already been provided, and maybe a little bit of a background of what the department understands this language to be doing. So it is amending the workers' compensation statute at Section 40, which is the section that directs insurance carriers and/or employers on making payment of time out of work benefits, cash benefits. We call them indemnity benefits to injured workers in instances when there has been a work-related injury. And it requires a certain type of paperwork filing called a memorandum of payment. So that section 1 above is talking about how the insurance carrier and/or employers is required to go about doing that. The additional language that's being added is requiring employers who make these supplemental payments to do 3 things. One, they have to notify the employee, we take that to be in writing, of a breakdown of those payments and the anticipated financial adjustment, which we understand to mean to be addressing this sort of overpayment or duplicative pay scenario that's been described, including any employee costs of withholding and the payment method option. I did hear some testimony relative to repayment option. We do not read this language to say that these notifications need to outline any kind of repayment option. We read it to be payment option. So our interpretation of that, it is the method by which the supplemental payment itself is being made. So I'm not really sure or clear what the intent there is, but that would be our interpretation of the language as it stands. The proposed language is also requiring that the employer issue this notice to the injured worker within 30 days from the date of injury, and then every 30 days thereafter. So it's setting this additional or this new process into place that employers must comply with, and it's the employers, not the insurance carriers. As a couple of technical points that the department would highlight, the term supplemental pay is used in the proposed language is not a defined one. We did hear some clarifying, I think, commentary and testimony about what does that mean, but I would note, and the department would note, supplemental pay is not a term that's defined in the workers' compensation statute, and we could see some confusion born out of a lack of definition of what does that mean exactly. On reading it as drafted, the department could interpret that in a couple of ways, and indeed did interpret it in a couple of ways. We interpreted it as explained over the course of this hearing. We've interpreted it as an employer who is continuing to make full payment of wages. Occasionally, employers do that. It could also be interpreted to mean an employer who is paying an employee to make up the 40% difference between the 60% that the insurance carrier is paying in comp benefits to kind of close that gap. So the application there without a definition really could be maybe perhaps more broader than intended. So we would highlight that. In relation to the notifications about deductions and withholdings, when you're talking about payment of wages, RSA 275 already sets forth certain requirements that employers have to go through relative to notifying employees about certain types of withholdings or deductions. That section of statute also sets forward mechanisms whereby overpaid wages can be recouped. So again, you're now this language would be adding a requirement to employers in addition to requirements that are applicable under RSA 275, new notification requirements, additional notification requirements, and notification requirements with different timeframes that they would also now have to comply with under 281A. And then finally, the department would note if this language were to go into effect, there is not a requirement that the employer, embedded within the language, that the employer is required to notify the department that they have done this. So as in terms of regulating whether or not it's happening or it's occurring, there's no mandate that the employer needs to copy the department or file a copy of that notice with the department so that we have it on record as part of their workers' compensation claim or otherwise to demonstrate that they are complying with the requirements. If an issue of noncompliance were raised and brought to the department's attention, there's not a specific penalty mechanism that attaches to this new language, so we would be looking at enforcement under RSA 273.11a, which would mean the employer would be issued a warning, would have 30 days in which to cure the violation or correct the violation, and then thereafter would be subject to penalty in an amount of up to $2,500. And with that, I am happy to take any questions.
I have two questions.
Sure.
First is, okay, the word supplemental. Would the department have language that could amend to make that clarified?
We would be happy to work on trying to come up with something. I do think again we might need a little bit of direction about what is the stated intent of what that's intended to mean. From what I heard at this hearing today, it appears to be the benefits that the employer is continuing to make payment of while the employee doesn't have a paycheck to do the withdrawals from. But so if we had that direction, we would be happy to work on coming up with language that would work for the parties.
Okay, and then also, would you recommend that an amendment be applied to notify the Department of Labor to close that loop that you mentioned?
I would recommend that if there was an inclination to have the language pass as drafted. I think that would help the department with compliance and regulatory oversight.
Okay, and could you provide language appropriate for that amendment?
We could, yes.
Okay, and Representative Flanagan, did you have a question?
Thank you, Mr. Chairman. So if I read this bill and I listen to your testimony, the only thing that really is substantive is the fact that they got to give notice 30 days after the person is on workers' compensation, because we don't know what supplemental income is. We don't know whether the employer is paying the cost or the employee has paid the cost. So, like I said, the only thing that is truly accurate in this amendment is 30-day notice.
The 30-day notice aspect of it is very clear to the department. I'll stand by supplemental pay is not a defined term. I mean, as it relates to the content of the notice, the language does provide certain requirements that have to go into that content, inclusive of the breakdown of the payments. I think you need to know what those payments are in order to break them down. So to that point, as well as the anticipated financial adjustments, as I said, we take that or understand that to mean whatever the repayment may be. It sounds like from earlier testimony that the intent is to have employees not be surprised by money that's owed back. So there's some there appears to be an attempt to include some substance within the content of the notice itself. I do think that clarification of what supplemental pay means could help give context to that substance.
Okay. Representative Avalani, sir.
Thank you, Mr. Chairman. Good to see you again, Deputy Commissioner.
Thank you.
Again, the definition of supplemental pay as an employer tells me that they're paying above and beyond benefits.
Yep.
Also, supplemental pay could be if the employer was paying the employee before their claim was active, and then the carrier pays a lump sum to the employee that duplicates that payment time.
Yep.
And would there be a mechanism for the carrier to pay back the employer for the salary portion? And there would be a smaller number at the end for benefits.
That's an excellent question. No such mechanism currently exists within the workers' compensation statute. If that were the intent or an idea that the committee had as an appropriate solution or resolution to these types of issues when they come up, certainly language could be crafted. I do think you'd have to look at that language and craft it specifically to address that need. But currently, no such mechanism exists in the workers' compensation statute.
Please.
If there was a mechanism in place for that, would that have eased the burden on the employee that came back to work facing that larger bill? Was part of it benefits only replacement, or was it part of it was payment of salary? They got a lump sum from the carrier, didn't pay back the employee, didn't pay back the owner, and now stuck with the larger bill at the end because they didn't do the follow-up.
It arguably could. I'm hesitant to speak on behalf of all employees out there, but it arguably could.
Thank you for right now, Mr. Chairman.
All
Thank
right.
you.
Representative Flanagan, and then Representative McKenzie.
Just a clarification here. You know, we've been talking about benefits as far as supplemental insurance, supplemental pay, but say the person's a salesman and he gets injured driving, going to the job or at the job that he's trying to sell goods and service, but he gets commissions. It's not his base pay. So his workers' comp would be his base pay, but then all of a sudden if he got $10,000, commission check, does that mean then he would be getting it? Does that mean that he had to now pay it back? Or does that mean he's going to get, the way this reads, supplemental income can be anything. And I just don't, I couldn't vote for this. The way it's presented. So it's confusing from a clarification standpoint.
Representative McKenzie.
Thank you, Mr. Chairman. I think the focus, if I understand this bill, is to be transparent. That employees should know what so the department would work with us, so work with the sponsors of this bill to at least get that part done. So we have an understanding of what they're gonna get hit with.
Yeah, we would be willing to do that, yes.
Because I think that's the focus of this bill. There's ancillary and, other things that buzz around this thing, but people should know, correct?
It sounds like that's the intent of the bill, is to make injured workers aware that on return to work, there will be a repayment at issue.
Yeah, so I think that's what they're asking for. Thank you, Mr. Chairman.
And Representative Avalani, sir.
Thank you, Mr. Chairman. Along those lines, if the employee does not come back, what happens to that balance?
That is an excellent question. As this language stands, there's not a mechanism built into this language. And again, this is falling under the workers' compensation statute. There's no mechanism for repayment under the workers' comp statute. There's a mechanism for overpayments under protective legislation, RSA 275, but that requires, it falls under 275-48. So the employee and the employer need to agree in writing. The amount that can be recouped from the paychecks is limited to 20%. There's a whole host of requirements that have to be met in order for an overpayment to be taken back by an employer under the parameters of RSA 275. If there's no paycheck to take it from, it's not so clear to us. I don't think that application would be the viable one. So So if the injured worker does not go back to work and this language passes as drafted, I don't know that there is a mechanism for it to be returned or recouped as drafted.
Oh,
Please.
so my original intent was to have the carrier pay the employer back for benefits up until the point where they take over. Would that solve some of the problem? I have a problem with the billing them 30 days while they're trying to get better, and then at the end, if they don't come back to work, they get a large settlement payment. They move on to something else. The employer is out their dividend.
Yeah, I understand I understand that. So certainly, if that were the direction that the committee determined to go in, language could be crafted to that effect. I do think we'd have to look at that language, and we would be happy to work on it if that's the direction that the committee wants to go in. But certainly, a process or procedure for that could be added, and I do think mind would have to be paid to how that is put together so that it's an appropriate one and it's working with all other areas and aspects within the workers' compensation statute.
Yeah, final follow-up.
Please.
And then I know that 275 is the employer payment issue and everything else. There would have to be something on the back end. If that employee does not come back, how does that employer recoup his lost?
Correct, and currently there is no such mechanism within the workers' comp statute or 275 that I'm aware of.
Thank you, Mr. Chairman.
Okay, got it. All right. Seeing no further questions, thank you, ma'am, again for your testimony. Sir. Please.
For the record, Tyler Gouveia with the Professional Firefighters in New Hampshire. I just received word and wanted to put it out there. So the definition of the supplemental pay that we were using while crafting this language was what's defined under the retirement system. So 100A, RSA 100A would be where that definition was that we found.
And can you clarify what that says right now?
I don't have it pulled up in front of me. I'd be more
So
than
it's
happy to bring it
reference
to the-
RSA,
Yep.
supplemental reference RSA.
Correct.
Gotcha. Representative Avalani.
If you could.
Yep.
And for the department as well, if they want to chime in after this, the Department of Labor doesn't have jurisdiction over the retirement system. So they would not be using that as a reference for 275 or even 280, 281, which you're talking about right now. Would that be correct? That would be it. Thank you.
Okay.
Thank you, Mr. Chairman.
All right. Yes.
I don't want to jump the gun on exec, but just something we need to be thinking about. The last two bills seem to have some hiccups that are in need of a adjustment, and there's three ways to address that. One would be to retain them. Two would be to, in a frantic panic, try to get amendments put together before 2:00. And the third would be to schedule exec at a later time. Just want to throw that out there because I don't want to say that at 2:00.
Yeah, no, we're not going to try to do amendments before 2:00. That's not happening. Okay, so we'll determine what we'll do at 2 without amendments. Good points. Okay, I'm going to close the hearing on SB 169, subject to any further comment, question, and open the hearing on SB 171 relative to required pay for remote work. And for that, I have one pink card. Is there anyone here to introduce that bill? I got pink cards arriving from both ways.
That's my summary.
Okay, yeah, again.
Danielle, I need to go over this.
Yeah, can you do that? And I recognize Representative Avalani to introduce the bill.
Thank you, Mr. Chairman, members of the committee. For the record, Representative Lino Abalani, representing Carroll County District 4, introducing Senate Bill 171, which looks to exclude employees who work remotely from certain reporting time payment requirements.
Thank you, Representative Avalani. And I'd like to call Miss Milio. And as previously, your testimony was clear and concise, so I look forward to hearing from you again.
And thank you for your time today. As you stated, my name is Allison Miliano. I am the co-owner of Blue Lion, or an consulting company based out of Southern. We serve hundreds of businesses and nonprofits here in the great state on matters to HR, including payroll processing, policy creation, administration, as well as guidance related to regulation. Our team of over 14 HR professionals has a breadth of knowledge across many industries, as well as a clear size and vision. I am here today to voice my support of Senate Bill 171 and the proposed update to RSA 275-4040-A regarding required. As a business owner and employer in New Hampshire, I understand the importance of fair compensation to employees. However, the current interpretation of this law has created uncertainty and undue hardship for employers who are trying to comply. With each new director, the Department of Labor seems to bring a different interpretation, making compliance a moving target. This inconsistency is unfair to employers and employees. The proposed update provides much needed clarity, specifically to ensure that employees who work remotely and perform brief tasks such as answering emails on a Saturday for 30 minutes are not entitled to 2 hours of pay. This aligns with modern work practices and prevents an unintended financial burden on the business. In my last 10 years of working in HR and operations, was imperative to look at not just the letter of law, but the actual spirit and its intent. For those 10 years, I and most of my HR colleagues interpreted the 2-hour minimum regulation to ensure employees who made an effort to ready themselves and commute to work did not incur a greater burden or cost than they were to receive in compensation from their employer. I interpreted this protection for employees in industries like hospitality, from being scheduled to come in for a shift as a server, only to arrive to work to potentially having arranged childcare, costly gas or a bus ticket, and today maybe an Uber drive, from being sent home immediately because the employer was slow. It was to provide a protective net to employees that their efforts to travel to work not were not needed.
Excuse me, ma'am, could you push your mic?
This whole time?
No, we've heard you. You pronounce and enunciate very well, but the outside world can't. So you're good.
Do you want me to
Continue
start
on.
again?
No, continue on, please.
Just kidding. In a post-COVID era, where an average of 1 in 3 employees is in a typical office setting now work entirely remotely or hybrid, this law needs to be amended to consider this aspect of today's work-life balance. Today's employees are able to work from home and balance a slew of Zoom meetings, emails, projects, Slack, and Google Chats, and also have the ability to change the laundry, start the crock pot, or take a lunch that allows them to work out on their Peloton without having to commute to a gym and focus on their health. I think the interpretation of the law needs to be clarified and documented for remote workers, removing any ambiguity or confusion. If an employee wants to log on a Sunday to get organized for Monday, checking emails and prioritizing their week for 30 minutes, the employer should not be held accountable for paying them for 2-hour minimum rule, nor should the employer be expected to reprimand that employee for going above and beyond without being asked. All legislation should be clearly defined, leaving no room for shifting interpretations that disrupt business operations. This bill ensures consistency, fairness, and clarity for all parties involved. I urge you to support this bill and provide New Hampshire employers with the legal clarity they need to operate fairly and effectively.
Thank you for your testimony.
Thank you.
Questions? Representative McKenzie.
Thank you, Mr. Chairman. You refer to clarity in terms of remote work.
Yes.
And that the employers should be clear and everything should be clear, but that's not the case, correct? The remote work is really hard to get your hands around. Is that?
Thank you for the question. I think there is clear lines with remote work. I operate a fully remote company. All 17 of my employees work from home. We do not have an office. We are 100% remote. There are times that they do travel to client sites, but they're fully remote.
Mr. Chairman, follow up, because I
Yes,
think
sir.
that's an important issue. So tell me how they structure their days.
So
Remote workers, and how you know when they're working, not working, how you know when they're working at 8 o'clock or answering the phone, those, can you explain that?
That is a great question. There are many tools in today's environment that you can actually know when they're logged into their computer, when their mouse is moving, how many clicks they're doing. There's those monitoring systems. We personally do not use that in my system. I hire good humans, so I trust that when they tell me they're working, they're working. However, I also know that there are times that people are accessing their emails on their phones and perhaps maybe didn't punch in properly. I plead the fifth with the Department of Labor sitting here. But it's important because you are correct. There, oftentimes employees are doing things in their home offices, logging in real quick to answer something, going and running to do something. But yes, there are ways to monitor what people are doing when working at home. But I think the conversation about allowing remote work and not is a different conversation than this bill.
For follow-up, yes, sir.
So when somebody logs on, if you were in a normal place, you'd log on, you'd do a timesheet, you'd do something like that. How do you keep track of when those employees are actually working and when they're off? Do you keep track of a system of tracking all of that kind of stuff so you know when they're actually working?
Thank you for the question. Yes, it's exactly as if they were sitting in an office. In 2025, I don't want to give statistics, Department of Labor may know better, but I would say 95% of employers are using electronic time systems. My significant other runs a garage door company. All of his staff punches in and out on their phones. So industry agnostic. People are using technology to punch in and out. My specific team uses QuickBooks Time. So they're logging into their computer, punching into their time clock, working. So they're punching in and out when they're working.
Thank you.
Seeing two more questions, we'll refer to Representative Staub. Ma'am, over to you.
Thank you. You mentioned that someone might check in on their email and just answer a quick question, but then expect to be paid for 2 hours. Is that a thing that happens?
Thank you for your question. So I think you bring up a good point. In my now probably way more than 10 years of doing this work, have never seen an employee request the 2 hour. I've always seen it when the Department of Labor comes to do an audit. So if you get your lucky ticket drawn and the Department of Labor comes in and looks at your books and they found that because you are having people punch in and out and they audit your time records and they find that someone worked for less than 2 hours, however, you did not compensate them for the full 2, you're penalized and have to pay double wages and penalties for that. But I have never heard of an employee requesting. In fact, my entire team's probably watching me now and agrees they want to be able to log in on Sunday, get cleaned up for the week. And right now, my directive is they're not allowed to.
Because you have to pay the 2 hours.
Because I'm not going to pay them 2 hours
So
for a
you
half
want to
hour
pay
of
them for
work.
the 20 minutes it takes them to do.
I have no problem paying you for the work that you've provided.
Gotcha.
Yep.
Okay. Representative Cahill.
Thank you, Mr. Chair, and thank you again. So if a person is a remote worker and they plan on working whatever hours and days that are assigned, and for some reason they don't get the memo that, no, they don't need to be working today because something happened and I don't need you to be doing your job, would you then feel that you should pay them the 2 hours?
I personally would not because they've not left the house. Most likely they are in a Zoom mullet, which means they have a business on the top, still sweatpants on the bottom. They're going to, within 5 minutes, be doing something other than working. Also, I would say the probability of a remote worker to not be working would be more on them than on me. And an example I would give you is loss of internet service. So I have had personally employees that were not able to work because they lost internet service at their home. Most of my staff will go to the nearest Panera, you might have seen them, and they'll hook up there. But oftentimes I've not, to my knowledge, ever heard of an employer saying, I don't need you to work last minute. Now, it may be something in advance. So an example of an advance notification may be a nutritionist or a dietitian who has a set schedule. And by Tuesday night, there's no work for Wednesday because nobody's scheduled appointments with them. Then they're off on Wednesday. So to me, that's plenty of notice to know that you're not working on Wednesday. Nobody's scheduled appointments. You're going to go on with your day.
Follow up?
For follow-up, sir.
Thank you. Well, what if your network is down and and they don't have the ability to log in, or any number of things that could happen to your business, and it's really your business, and they don't have notice, they can't pick up another job for that day. You don't think that the 2 hours would be warranted in that stage?
I don't.
You don't?
Because again, they're still at home. They're able to immediately start doing something else productive for their life. And they're not having to commute back home or anything like that.
Paul?
Yes, sir.
Thank you. But they're not getting paid. Whether they can, maybe they'll just do another load of laundry and do the ironing, but they're not getting paid. And their commitment was from you that they would be working that day and getting paid. So I wouldn't think you should pay them the whole day, but I think the 2 hours, I think this law was created for that situation. Although we're working from home today, I think you're still working for the employer as long as that's possible. And if you're prevented from doing that, reasons beyond your control, that's what I think. That's where I think I have a problem with the bill.
I disagree with you, but thank you for your question. I disagree with you, but I would say if you are going to go down that line, I would also, in addition, even though I don't agree with you, would also add much more language around the regular scheduled shift versus a Saturday for a half hour. So that's your keying on a very important part of what's missing from most of our legislation, which is clarity. So it is too broad at this time with not enough clarity. And unfortunately, with different directors at the Department of Labor, they bring their own interpretation. And that's where we're struggling to continue to operate effectively.
I just need a little clarification.
1 second.
Thank you.
So this, I said 1 second. I didn't say.
Okay, I'm sorry.
15.
Okay, yeah.
So in your mind, this legislation, does it add that clarity or more clarity?
Yeah, it adds clarity. So I want to be very transparent. When Michelle Small was in charge of the Department of Labor, and I'm going to mispronounce her title, but I believe she was Director of Department of Labor, she interpreted this regulation not to be for remote workforce. So when she would go around the state, as the state still does, they go around, they educate our employers. Our employers were educated. It is not for remote workers. Fast forward a few years later, or a few years ago, Lexi Rojas took over. Lexi Rojas has a different interpretation of this bill. I'm not saying it's right, wrong, or indifferent. Her interpretation is that nowhere in this legislation does it state that it is not for remote workers, which she is not incorrect. However, you now have an entire population of employers that thought they were trained 3 years ago, aren't going to training now, and they're actually in violation. So I think allowing the flip back and forth, it needs to be, because remote work is so prevalent, it needs to be defined.
Got it. Do you need more clarification?
Yes, I do.
Then please ask your question.
I thank you. So I'm reading the last line, and really just a section of that, in which I'm confused. The employee shall perform whatever duties are assigned by the employer at the time the employee reports to work. The employee is reporting to work at their computer in their pajamas, but they are reporting to work right then and there. But the employer has, for some reason, said, I don't need you today, don't work. And so what exactly does that sentence mean? They should do the work when they report to work.
It's not part of the bill.
Hang on, let me read this. However, the employer reports to work after the employer's. This is saying that if I've notified you that you're not working and you still come.
Well, they didn't get the notification. You tried, but they didn't get the notification. They log in and they're ready to work. Right. And you said,
I would say as an employer, I've notified you, I've done my part. You not paying attention to the notifications that we pre-established was my way of communicating with you, should not be my burden.
I would agree. 100%.
so you should just answer. So the employee shall perform whatever duties are when at the time their employee returns to work. You're talking about another time, not that day when you notified them, but you're saying they should report to work another day and do the work. They shouldn't be working that day.
So this is saying that if I make my good effort to tell you I don't need you to work and you still show up, then I would have to pay you. So unsuccessful and the employer's prevented.
So let me just dive in here real quick. This is not what we're talking about. This is existing law that is not part of of the recommendation.
I think there's
in the
other people
bill.
that are testifying that can also help you better
We're
on
trying to change
this.
the interpretation of the existing law. That's the idea of this bill. And it's a little, that last sentence is a little confusing for me.
Of the existing law, which we're not talking about.
Of this, okay, the existing, yes, I guess this is not bold or italic.
So
Right.
it's already there. We're not voting
Gotcha,
on it.
Gotcha.
Okay. All right. Representative Avalani and then Mackenzie. Go ahead. Mackenzie, go ahead. First, sir.
Thank you. So the trend now is to have shared office space in locations, and Manchester has one of them. So I take it up, drive my car to the remote office, and I sit there and you call me up and say, we don't need you. So is that, they're going from, not at their home anymore, they're at the remote office, and that's a trend now, with people doing this. How does this apply?
That's a great question. I would say that it would be interpreted on who's paying for the office. So am I paying for that office space, which I have before? I had an employee that couldn't work from home. I paid for her office space. So then, yes, I'm paying for that office space. It's my office space. But if you chose not to work remotely, then I would say that that's just your choice of a place to work. So my employees sometimes work from, the back room at a dance theater or dance studio. They work wherever they want to sign in. Down at their house in Florida. We try to avoid that. Camera on, camera ready. Can't do that from the beach.
Okay, good. Representative Avalani, over to you.
Thank you, Mr. Chairman. Thank you for taking the question. You mentioned that you get audited when your ticket is punched. Have some of your
Yes.
customers been subject to wage complaints or DOL just walking in the door?
The Department of Labor will not tell you if an audit is based off of a complaint or a random audit. They won't give you that information.
Thank you.
Okay, thank you, ma'am, for your testimony. I appreciate it. And we have Mr. Summers, please. Sir.
Good afternoon, Mr. Chairman, members of the committee. For the record, my name is Mike Summers, President and CEO of the New Hampshire Lodging and Restaurant Association. We are here in support of SB 171. This is a bill we actually asked Senator Ricciardi if she would bring forward for us. We had heard complaints from a variety of members who had kind of gotten into the scenario that you just heard about. Basically, what this does is that if an employee does not leave their home and may log in for 15 or 20 minutes, then we would pay them for the 15 or 20 minutes. It's for time worked, but we would not be paying them. We don't believe it's fair and equitable to be paying them for the 2 hours that's essentially compensation for travel to and from work, et cetera, because frankly, they haven't left. So that really is the crux of this. We worked with the Department of Labor, and so the language in that section C starts on line 9. It just clarifies that you are still required to pay them for time worked. And to the discussion earlier, every business has a slightly different scenario of method in which they track the hours. Employees are required to fill out a timesheet or electronically, however it may be. But essentially, they're still required to pay for time worked. We just feel it's a little bit unfair that the expectation is you would have to pay for 2 hours of travel, time, expense, et cetera. It seems unnecessary. So that's it. I'm happy to try to answer questions.
Representative Avalani.
Thank you, Mr. Chairman. Thank you again, Mr. Summers. Scheduling an employee. So Monday, so you schedule your HR staff Monday through Friday. They on their own go on a Sunday to check their emails for the coming Monday morning. They would typically be working outside of their scheduled hours.
Correct.
Why would we still have to be required to pay them for 2 hours even though they weren't scheduled?
Well, that's really kind of the crux of the issue, because when you work from home, you're more inclined to slip into these kinds of habits, I guess. I know I would check my email on a Sunday just to see what I was walking into on a Monday. So I think that's really kind of the crux of the issue. I would say that if it's outside your scheduled hours and you put in 15 minutes on a Sunday and you put it on your timesheet, I think every employer would happily pay that. You're preparing yourself for the week, you're getting the work done. I think that just makes sense. But again, to then during an audit be told that that 15 minutes is not good enough, you got to pay 2 hours. I think that's where we run into the problem.
Follow.
Please.
So if they work 15 minutes on a Sunday, you say, okay, well, you put in 20 minutes on Sunday, take an extra 20 minutes off on Monday.
Come in late Monday, sure.
That still wouldn't fly with the department.
Ooh. I think it would depend on, are you paying them hourly or is it going to be like a salaried position? I think if it was hourly and they essentially clocked in at 9:20 instead of 9 a.m., I would think that provided you could show that there was a hey, I saw you jumped in on the online on Sunday, you did a little 20 minutes worth of work, don't start till 9:20 tomorrow. I think provided that communication was there and shown, I don't want to speak for the department, but I would think that they'd be reasonable enough to say that would make sense.
Thank you. Thank you, Mr. Chairman.
I would hope. Yes.
Representative Granger.
Thank you, Mr. Chair, and thanks for taking my question. So do you know if employees ever make rules saying that if you work on Sundays, you must work at least 2 hours, otherwise you're not allowed to work at all, or any rules of that nature?
I've never known an employer that would have a requirement like that, no.
Thank you.
Representative Labry.
Thank you, Mr. Chair. Thank you, Mr. Summer. There's already municipal employees and county employees that don't get the 2 hours. There's already snowboard instructors and ski instructors that don't get the 2 hours. And now we want to exempt remote workers from not getting the 2 hours. So just a point here, where does this end? It just feels like people just keep adding to the pile here. And, you know, at what point, wouldn't it just make more sense to pull the whole 2-hour requirement across the board?
Well, I can't speak to why we have all these carve-outs. That predates me, I'm sure, by a lot of years. I appreciate the question. Frankly, I think a lot of businesses, particularly in our industry where you legitimately are scheduled and you leave home and you drive to work, I would think most of our businesses would likely maintain some threshold of 2 hours because they realize that the person has taken the time, they've driven their car, they've expended gas, time, effort, and resources to get to work. They're either going to make them work a couple hours to, justify it, or they're likely just going to pay them for the 2 hours. So I would suspect that most businesses who wanted to kind of set themselves apart from their competition would likely maintain a policy like this, I would think. I think where people really get caught up is when it's in the remote work scenario. And hence the reason for the bill. I think it just becomes a challenge that you didn't get dressed, you didn't necessarily leave the house, you didn't drive your car anywhere, and then you're still required to pay 2 hours. I think that's the real rub. But I can certainly appreciate your point that, we have a carve out here, a carve out there, and, who's next to ask for the carve out? I think that does become problematic, so.
For a follow-up, sir?
Thank you, sir. Just another point. It just feels like this law is, and I agree with Representative Cahill, this is confusing, unenforceable, and discriminatory. And it just feels like we're picking factions here along the way within new add-ons here and existing. And so that's my concern with it. I don't have anything further. I mean, New Hampshire's one of 8 states that has this 2-hour minimum requirement.
Correct.
That's it. There's 42 other states that don't have anything to do with this. I just feel like the carve-outs are a little bit too much, that's all. Respectfully.
And I can appreciate that position, and frankly, I think the reason we're here is because the clarity is the challenge. I'm not sure if this is necessarily the solution. Obviously, that is the job of this policy committee to decide. But certainly, it has created an awful lot of headaches for businesses, particularly in our industry. Yes.
Okay. Representative Avalani, sir.
Thank you, Mr. Chairman. Your testimony earlier was for this to clarify the language for the department so they can go in and do apples to apples instead of apples to oranges when they're looking at certain remote work time cards.
Well, I think what I was trying to get at is I think that there is a difference between a person that works at a facility. Could be a restaurant, could be manufacturing facility, somebody who has to travel to a place. I think there is a difference between that type of worker and a worker who works from home, who never leaves their home, in the level of effort, resources that are dedicated to getting to the place of work, if that makes sense.
Thank you.
All right. Seeing no questions, sir, thank you for your testimony as always.
Thank you.
Mr. Garrigan from the Department of Labor, sir.
Good afternoon. My name is John Garrigan. I am General Counsel with the Department of Labor. The department is neutral on the bill. I do want to clarify a few things and then get into a technical suggestion. So just to clarify, the way this statute operates is that it only kicks in when employees are reporting to work at the employer's request to show up. It's not when employees are just opening their emails on the weekends. There are some administrative rules that are attendant to this law. They're in our labor 803s. They allow, kind of in short, a employer and an employee to set essentially a schedule and expectation if there are going to be times where employees will be regularly asked to work for less than 2 hours on any given day. So that if that expectation is set ahead of time, then this rule wouldn't kick in. It really is for those times where the employer calls you up, says, "Hey, I need you to work." You go in, they don't need you to work. That's where this rule kicks in. In terms of some previous speakers have mentioned like random audits. We don't. Our process is not to do random audits. We don't have a big lottery wheel. We're complaint driven. So when complaints come in, we will respond to those in various ways, including an inspection. So now to the technical suggestions. The bill does not define what a physical location or working remotely is in the context of this law. So as the department applies it now, the location of your work is where you're working, wherever that may be. That's also how the federal government defines it for the enforcement of their laws as well. Our concern is that the way this is worded, the amendment is, or sorry, the proposed language is worded. I think it could raise confusion where a individual is working remotely, but not necessarily at an employer's like brick and mortar location. So for instance, let's say and there's a lot of examples. Let's say you're a plumber and you're working at somebody's house, or you're an employee who's working at a client's site and not necessarily your own office. It could raise some of those gray, blurry lines. So our recommendation would be, and we understand the intent of the bill is, folks who are genuinely working from home. So our recommendation would be, if that is the intent of the bill, to maybe add some more clarity to specify if somebody's working perhaps at their domicile or whatever other ways could be specified, so that we're talking about people who are genuinely working from their home and not in some other off-site capacity. That would provide more guidance, not only for the department and its enforcement, but also for employers to comply with the law, which helps everybody. So I'm happy to take any questions.
Representative Library.
Thank you, Mr. Chair. Thank you for taking my question. With all these carve-outs, do you feel like you're overwhelmed with this? There's a lot to keep track of here. How do you feel? Share your feelings with us.
The department enforces this law very, it's one we commonly enforce. As to the carve-outs, that's a policy decision for the committee as to what examples of industries where there should be these carve-outs exist. So we enforce what's written, though we do always enjoy more clarity.
All right, Representative Granger.
Thank you, Mr. Chair. Would clarity increase if we just repealed this whole section?
I'll defer to the policymakers on that.
Okay, thank you.
And Representative Kesselring.
Thank you, Mr. Chair. So just a question. I know we're talking about repealing and all these things. It seems like there's some clarity issues too with how they're interpreted. So you're saying one thing, we've heard different things in testimony on how this can specifically be interpreted. So who, let's say, is the person that has the final authority on that?
Ultimately, it's the Commissioner of Labor.
Okay. Follow-up.
For follow-up.
So then what is the recourse if somebody doesn't agree with that to the Department of Labor?
Yep. If we bring an enforcement action on the basis of our theory of law, and we are able to win at the administrative level, there are appeals rights that are available for anybody aggrieved by that finding, either to the Civil Penalty Appeals Board or up through the court system.
Okay. Representative McKenzie, you got one.
So the question I have is that the assumption is that somebody is working at home in this debate, and that they're not traveling to do it. But the reality is that some people are remote workers that don't work at home. Correct? I mean, some people may go to Dunkin' Donuts and work. or they may go some other place and work. So they're not necessarily working out of their home.
Yeah, that's one of the reasons we think more clarity should be here. That's one of what we see as one of the confusing scenarios is what is working at home.
So would you think that the whole remote work environment, that we should take some time as a labor committee and as a legislature to look at the new emerging remote work scenario? Because it doesn't seem to be enough infrastructure in the law to necessarily address this changing work environment that we're currently in.
To the extent that the committee wishes to take more time with this through one of the various mechanisms, the department would be happy to participate in those proceedings and offer our suggestions.
Thank you.
Representative Maloney. Representative Cahill.
Mr. Chair, thank you, Attorney Garrigan. So we're concerned with people getting up and getting dressed and driving someplace, but a lot of people who work from home get up and get dressed and, schlep their kids to the daycare, which they still have to pay for, even if they're not getting paid because something happened at their employer. Do you think there's the 2-hour pay might be something that we should keep in those situations?
Again, that's a policy question. We'll defer to the legislature on what the right policy for that is.
Thank you.
Representative Maloney, go ahead.
Thank you, Mr. Chairman. For what we've heard and the testimony we have is that this came to us out of time card violations, basically. People punched in half hour on Sunday, half hour on Saturday, can't sleep at midnight on a Monday morning. Basically for remote work. Clarifying Section C tells me that an employee who works remotely, period, would be exempt from the 2-hour minimum, which would give you clarity when you're going into a time card situation, violation situation, which we've heard, would give you clarity on, instead of interpreting, well, is this a physical employee or is this a remote employee? This tells you that remote employees are now exempt from this law. So the time card violation scenario would go away in those instances. Does that help or hurt this legislation?
We certainly understand the intent of the legislation to be going kind of down that road. Our concern is that the way it's currently written, there could be these blurry scenarios of you're sort of in person and you're not really in person, where expectations could be blurred. I mean, the way the department looks at it now is really kind of an expectation-based analysis. And it gets complicated where you have an employment situation perhaps where an employer has kind of the soft expectation that employees are always available by phone or by email or by messaging. And so if an employer sends a message on the weekend to an employee saying XYZ ABC, and the employee takes that opportunity to respond to that message, now you may have that gray area where the employee is now working at the employer's request, and maybe they're an hourly employee, but they're really sort of being treated like a salaried employee. There's the working from home has created a lot of these gray areas where, it's not as, in a lot of employment situations, it's not as clear as, say, I work at a restaurant. When I'm at the restaurant, I'm at work. When I'm not at the restaurant, I'm not at work. Sometimes those lines get blurry.
For follow-up, yep.
So we still heard from the employers that if it is initiated by the employer, I have no problem paying the 2 hours. I initiated the call, they initiated the call. But if an employee took it upon themselves with no direction from the employer to log in on a Sunday afternoon for a half hour, does this clarify where your time card violation comes from?
So the department's interpretation now is that that already would not be a 2-hour violation because the employee hasn't reported at the employer's request. Maybe that's a conversation between the employer and the employee about what appropriate work hours are. That's a different thing, but we wouldn't prosecute that as of now. If the employee took it upon themselves to open up their own laptop and answer an email, say, they would be owed for the time they worked, but not for the 2 hours.
For a follow-up, sir.
Thank you. But technically, under this, if they log in for 5 minutes, they would be anticipated to be paid for 2 hours, even though they initiated the work upon themselves. The crux of it is getting the employers out of hot water because an employee took it upon themselves to work on a Sunday for a half hour, logged into their time card system, logged into the system, logged a half hour's worth of work. Now they're audited because you guys walk in the door. Now they're on the hook saying, okay, well, he worked for a half hour. You only paid him for 40 hours this week. You should have paid him for 42. Does this help you guys get to the point where you can exempt that half hour of the employee taking on that job, taking upon themselves to do that?
No, I understand. I mean, I think if those definitions of what working remotely and working at the employer's request are clarified, then yes, it could clarify those situations.
Thank you.
Representative Staub.
I think you might have covered this earlier, but there are people who, when they go to work, are not going to the office. For example, if I work for a company that cleaned grease traps at restaurants, and I get up in the morning and I go down the street to the local restaurant that I'm supposed to spend the day cleaning their grease traps, and I find that the plate it's closed, the place is burned down overnight because I didn't get there in time. Would that be considered someplace other than the employer's physical location, or does that restaurant become the physical location of the employer?
So the way the department analyzes it now is the physical location of work is where you're working, whether that's your home, your off, like an actual brick and mortar, Acme Corp office building, or if you're an on-site type of service individual, like a plumber or a grease trap cleaner, or you're at a client's site, you're a tech support person. There's a lot of examples. So, yeah, it could be that you've reported to work at that location. We would certainly, as of now, consider, the restaurant that you were going to go clean the grease traps at to be the location where you're at. So, and for instance, if you get hurt while you're at that restaurant, you're covered by workers, or you might be covered by workers' compensation insurance, even though it's not the employer's brick and mortar location. It can be a broader world than that.
Representative Kevin.
Thank you, Mr. Chair. So you said it would be helpful to have some clarification on what the definition of certain words were. Yeah, what is the current definition for the department for the employer's request, or how do you quantify that?
There's not a specific definition for it. We take it to be in what the words are, an employer's request. When you look at the plain language of that statute, it doesn't necessarily have to be in writing. It doesn't have to be in any particular means or manner. As I said earlier, there are administrative rules that allow an employer and an employee to establish schedules ahead of time for, if you just need somebody to do something for 1 hour on a Saturday, that's fine. That wouldn't trigger this rule. There are mechanisms for that, so long as it's an expectation and it's set in advance.
Representative Labyrinth.
Thank you, Mr. Chair. Last question for me. On the 2-hour minimum, in your mind, percentage-wise, how much of a percentage of a problem is this for the Department of Labor? Is this rampant, or is this intermittent, or is this the cause of your audits?
It's not the most common violation we run into. It is amongst, I believe, the top 10 or 12 violations we run into. It's not nearly as common as simply failure to keep records or something. We do that a lot. Yeah.
Representative Cahill.
Thank you, Mr. Chair, and thank you again, Mr. Kerrigan. Can you tell us if this is more prevalent in temp agencies, temp to perm, where the needs might change and that you don't get the notice and you show up?
I'm not aware of the breakdown by industry of where this is more common than not. I don't believe we don't keep statistics of industry by industry.
Thank you.
Representative Avalani.
Thank you, Mr. Chairman. So again, getting back to time card violations, if you're in there for another instance of slip and fall, or you're in there investigating something other than that, would this come up as a secondary violation if you found this just looking through time cards?
It could.
Thank you.
Okay, seeing no further questions, thank you, sir, for your
Thank you.
testimony. I appreciate your clarification.
Actually, I have a
And-
question on 803. If you could.
One more, if you could come back for 1 second. Go ahead.
You mentioned rules 803 is where a lot of the remote work lies.
Yes, it's 80303 H, I, and J.
H, I, and
There's-
J?
Yeah,
Does that also, do you guys have a definition for remote work?
not within our administrative rules.
Thank you.
Okay, good question. Okay, thank you
Thank you.
again. Mr. Reedy?
Thank you. I promise I'll stay within the minute or two that I said I was going to testify. I was sitting here. My name is Jim Reedy. I'm an attorney at Sheehan Finney. I'm a management side lawyer. I've been doing that for 36 years. I'm a frequent flyer at the Department of Labor, both U.S. and New Hampshire. I am intimately familiar with the 2-hour rule. I think the genesis of this is that prior to COVID, 6% of the U.S. workforce worked remotely. During COVID, at the zenith of COVID, it was 65%. We're now hovering around 30% of the U.S. workforce, and that may be stubborn, but there is a push among CEOs across the country to get remote workers back to work to fill those vacant spaces in expensive commercial real estate. So that 30% could be declining, but it's still something that, as Justice Gorsuch talks about in his book, Overruled, the multiplicity of laws have to keep up with the evolution of our culture, our society. So the intent, I believe, and we did talk with the Department of Labor about this, the intent was to address the novel aspect of remote work. The origin of this statute was going back to, in New Hampshire, most commutes are not longer than an hour. So if at the request of the employee came to work only to find out there's no power today, there's a low census, we don't need you, the option was put you to work doing your work at your normal rate, or go home and we'll pay you for the inconvenience. Largely, this issue is about expectations, and Attorney Garrigan mentioned that. It really is about expectations. My expectation for my schedule. I am here to work 8 hours. I came to work 8 hours. I made other arrangements and so on. So the expectation is that. Remote work, the question is whether or not there is the same expectation of being paid a minimum of 2. This came up during COVID. This came up with the number of people that businesses were shut down, people worked remotely, and there were some wage and hour audits. And this is not to criticize the Department of Labor. They're to enforce a protective statute. And this was not clear. The question was, are you working at the request of the employer, but you're not reporting to the employer's place of work? Going back to expectations, you're not commuting from home to the place only to find out you don't have work. So that is the legislative history on this statute. But there is a protection for the remote worker, and it's been mentioned several times here, and that really is just, if you engage work, you get paid for the time spent working. So if it's, I'm walking the dog, but I come back in and I'm working, I log on late. But the issues that came up during COVID with some of the audits were everything from texting, email, returning an email, turning on the laptop, thinking about it, performing work. And some of the instances where I didn't get to my training program today, so I'm going to bring it home and finish it, or I'm going to bring some work home and finish it. And the application in a couple of cases that I was involved in were, then you must be paid 2 hours, but it didn't take me 2 hours to finish that work or to respond to that call or email. The law addresses it in a couple of different ways. One is there is rounding in the law, rounding to the nearest quarter hour. The law also says employers must track all time commenced for the employee, time spent working for the employer from the beginning of the day to the end of the workday with any bona fide break greater than 20 minutes in duration. That's recording the time. Employers have to keep that record. The employee keeps that record, and that must end up in the continuum where they get paid for that time. The other thing is that it's one of my favorite definitions within the law. An employee gets compensable time if they are suffered or permitted to work for the employer. So that is just, if the employee is performing work for the benefit of the employer, they should be compensated. But it doesn't mean compensated at a default of 2 hours. So this proposal was meant to address that issue, that you're asked to come to the workplace and perform that work. But it also makes it clear, if you're that remote worker or that hybrid worker, if you commence work for the employer, you get paid for the time spent working.
Thank you. Questions, Representative Avalani?
Thank you, Mr. Chairman, and thank you for taking the questions. So this goes back to time card violations. An employee on their own volition clocked in on a Sunday for a half hour.
Mhm.
Department of Labor comes in, does an audit. You should have paid them for 2 hours. Should we just repeal this section, in your opinion?
There is a benefit to this section, and I think the benefit is, again, going back to managing expectations.
Mhm.
Now, there were carve-outs. There were carve-outs for municipal workers. There was a carve-out. I've been around long enough. I was a part of that carve-out for ski school instructors. And why was that? A ski school instructor's expectations were, I'm going to come in and teach a class, but if I show up on the mountain and there's nobody there,
Don't get paid.
should I be paid for 2 hours? Well, no, because part of the deal with the ski school instructor was I get to ski for free all day. And they didn't have an expectation of working 2, 4, 6, or 8 hours. They knew that when they came there, they were engaged for that purpose. Yes, I go back to, it's a good book, Justice Gorsuch, managing, it's overruled. It's, so some laws have to change and catch up and evolve. And at some point, is it eroded or watered down so much that it isn't necessary? I can't respond to that. I'm not a legislator. I'm not a policymaker. I'm just a management side lawyer that has to deal with some of the fallout from what we believe to be a misapplication of the original intent of the law.
Representative McKenzie, and then a follow-up.
That said, if I'm hearing this correctly, the Department of Labor has represented that the situation where somebody logs on for an hour or half an hour is accommodated in the law. Currently. So they're in their hall. I thought that's what the deal said to us. And if it's not, then I'll be corrected. But I thought there was an accommodation that was in the current law that allowed people to do short-time work. That's not the case.
My understanding, Representative, is that if a remote worker logs on or performs any work for the benefit of the employer, regardless of how much time is involved, they are compensated for that. They should record that time.
For follow-up, sir.
At the request of the employer.
That's true. But the other thing I mentioned, Representative, was the suffered or permitted to act on behalf of the employer. In that case, that is compensable time. So the example I gave is I took work home. I'm doing additional work. I'm responding to a call from my supervisor. I came up with a great idea and I texted my supervisor. So it's not, they didn't initiate it, I did. Arguably, that's compensable time. Now, there's a de minimis rule that is applied under federal law, and the question is, it's the nearest quarter hour. But the application, generally speaking, is it doesn't matter if it's a minute, or it doesn't matter if it's 15 minutes. It should be it should be compensable time. The question here with this law is whether or not that gets applied to remote workers, regardless of how much time they do. Should they get a default of at least 2 hours of work?
All right, great. Thank you for chiming in. I appreciate your testimony.
My pleasure.
All right, seeing, yes, ma'am. Would you like to augment or amplify your testimony?
Very quickly. So I just wanted
If
to.
you could restate your name
Sorry.
for the record. Thank you.
Is this mic on? Allison Miliotto, owner of Blue Lion. So I just wanted to comment on your question, Representative McKenzie, about the Department of Labor did just testify that they don't hold this for if I punch in on a Saturday and work for a half hour. This is one of the challenges we have as employers. I will testify. I had a conversation last summer with Lexi Rojas about this exact same question, and she told me that if I had an employee punch in on a half hour on a Sunday to work, I was to pay them for the 2 hours. And her response was I needed to write them up and tell them that they should not be working on the weekend. And it was deemed that it was at the employer's request because they would not be answering emails if it was not for my request for them to be responsive to their emails. So she had a different interpretation than we're now hearing, which then highlights the entire problem with this legislation is it needs further clarity. That's it.
Did I respond to that, sir?
Yeah, but I just need to, so are you for or against this bill? Because you came in
I'm for
it,
the bill. I'm for the bill.
but you just said you weren't.
No, I'm for the bill. I'm saying that one of the challenges we have, which is the reason we need the clarity that this bill provides, is that the Department of Labor can kind of go one way or another.
Okay.
So this bill provides the clarity that all remote work, that half hour on Sunday, doesn't matter. Because
Okay.
Lexi Rojas says it is, he says it doesn't. This bill will answer the question.
Gotcha. And Mackenzie for
Well, I would
Representative
just say
McKenzie.
that I would like to know what the law says. That's what I would like to know. If the law is already here, if the law is already in place, the interpretation is in place, by the Department of Labor, why do we have to do this?
The law is not, the law for remote work is confusing, and this is to clarify that remote work.
Yeah, the law states at the employer's request. So their interpretation and mine are different.
Okay, good. And go ahead. Because you have to.
I do. I've been harping on the time card violations. Is that where this came from? Was one of your clients had a time card violation and was forced to pay the 2 hours?
Yeah,
Thank you.
correct.
Okay. All right. Seeing no further pink cards and no further questions, I adjourn the hearing on SB 171. And for an announcement, Representative Sullivan.
Democrats, we've been informed that the Finance Committee is still on in Reps Hall. I'm looking at them on YouTube. They're still on. And our 1 o'clock caucus will begin 10 minutes after they get done, whenever that is. And I understand we have a 2 o'clock appointment. It is what it is. We'll be here at 2. So
Okay.
be here at 2 and stay tuned on the caucus. And Mr. Chairman, I'd like to talk to you about procedure at 2 o'clock, but we can do that offline.
Yeah, no, that's smart. And Republicans, let's hang tight here once the room is emptied and then go to lunch after. We'll just have a quick huddle, see where we want to go. So we'll do our caucus right now, then go to lunch, then come back in the next 50 minutes. Very tight, but thank you so much for your patience, guys. Great day, and I will see you at 2. All right. Appreciate everyone getting back. I'm opening the executive session on House Bills 28, 67 FN, 169, and 171. And we'll address those individually as we go. On Senate Bill 28, Representative Kessler, do you have a motion?
I move ought to pass.
And do I have a second?
Second.
Representative Staub, or Representative Schultz, second, good. And would you like to speak to your motion?
Thank you, Mr. Chair. Yes, I think listening to these hearings is definitely a lot more that we need to do to be able to help people that are suffering from PTSD, especially first responders. So I think this is one small step to move forward. So.
And would you like to speak to your second, ma'am?
That was well said. Thank you.
Okay. Is there any discussion? Representative Sullivan?
Yeah, and in reading the RSA 281A:16, I actually read right past the fact that it was talking about trauma. And it didn't strike me that it wasn't just the single type of trauma that causes PTSD. It could be trauma as in the carpal tunnel or any other type of issue that might arise. And what this bill is doing is it's simply making sure that PTSD is treated as any other traumatic injury. So I think it's well intended, well crafted, and a good idea. I'll vote for it.
Okay. Are there any other comments or discussion? Seeing none, Mr. Clerk, if you could call the roll.
Representative Avalani.
28 OTP. Yes.
Representative Flanagan. Representative Guyson.
Yes.
Representative Warden.
Yes.
Representative Drago.
Yes.
Representative Granger.
Aye.
Representative Farrington.
Yes.
Representative Hall. Here. The clerk is yes. Representative Labrie.
Yes.
Representative Sullivan.
Yes.
Representative Cahill.
Yes.
Representative Ryan.
Yes.
Representative Susie.
Yes.
Representative Foss.
Yes.
Representative McKenzie.
Yes.
Representative Schultz.
Yes.
Representative Leclerc.
Yes.
Representative Staub.
Yes.
And Chairman Creighton.
Yes.
18 to 0. 18, yeah.
The vote is 18 to 0. Is there any issues with putting this on consent? And Representative Councilman, you got the blurb on this? All right. And Representative Amalani, do you have a motion on HB 67? I tell you, yeah, it's not here. He's not here.
He's stuck in the Senate.
Okay.
Mr. Chairman, I move Senate Bill 67 FN as ITL.
And do we have a second? Representative Granger seconds. And can you speak to your motion?
Thank you, Mr. Chairman. There was a number of questions with this bill relating to timelines, payments, and everything else. I think that it gives the sponsors and other people time to work on a timeline to resolve the issues that were brought up today. Outside of our being able to do that, I think a lot of people need to be at the table to do that, to come up with that fix. Thank you.
Okay. Any other comments or discussions on this bill? Representative Granger?
I'd be willing to co-sponsor a bill of this nature next year. However, we need to figure out a number. And that seems to be the biggest sticking point is we don't have a number. Thank you.
Representative Sullivan.
Oops. And that number is somewhere between 15 days and 18 months. With that extreme a range, I think it's a pretty heavy lift. Probably one that this committee doesn't want to take on. So I'll vote in favor of ITL.
All right. Just for the record, also, I agree with Representative Sullivan that I think there is a there on this, that number needs to be determined. I would rather not take this on. The Senate decided that this was the thing to do, and I'd rather give it back to them to do. And so by ITO on this, we'll be able to make a tabling motion on the floor, get it back to the Senate, and then hopefully come back with something that we can work with in the future.
And that tabling motion would allow either the Senate or the House to come up with a bill.
Yeah.
Or both.
Yep, I'm perfectly good with that. Any other comments or questions on SB 67? Seeing none, Mr. Clerk, could you call the roll?
Representative Avaloni,
Yes.
Representative Flanagan, Representative Giason,
Yes.
Representative Warden,
Yes.
Representative Drago,
Yes.
Representative Granger,
Aye.
Representative Farrington,
Yes.
Representative Holman. Clerk is yes. Representative Labrie,
Yes.
Representative Sullivan,
Yes.
Representative Cahill,
Yes.
Representative Ryan,
Yes.
Representative Susie,
Yes.
Representative Foss,
Yes.
Representative McKenzie,
Yes.
Representative Schultz,
Yes.
Representative Leclerc,
Yes.
Representative Staub,
Yes.
Chairman Creighton.
Yes.
And that's 18-0.
18-0 ITL. We will not put this on consent, so we will allow it to come to the floor. This closes the exec session on SB 67. I'd now like to open the executive session on SB 69, requiring employers to provide certain information regarding cost sharing to employees receiving workers' compensation benefits. Representative Farrington, do I have a motion?
I move inexpedient to legislate.
A motion on the table is inexpedient to legislate. Do I have a second?
Mr. Chairman.
Representative Avaloni is a second. And Representative Farrington, do you want to speak to your motion?
Yes, we found that there was ambiguity in the language about supplemental pay. The notification was burdensome with the 30 days of notification.
Okay, are there any other discussion? Representative Avaloni.
Thank you, Mr. Chairman. This gives us a chance to look at possibly having the carrier pick up some of these costs before cutting a check to the employee for the overlap in payments for salary. Also, would be able to further define supplemental pay, so it's actually in RSA 275, which is our protection notifications for payroll and things like that, and also to adjust the 30 days invoicing to make sure that either the carrier does it or the employer, and make sure that we're looping in the Department of Labor. Thank you, Mr. Chairman.
Okay, thank you. Is there any other further discussion? Representative Sullivan.
I'm going to oppose the ITL. I understand the ambiguity with the supplemental, but because this is a notification bill and nothing more than that, I don't think there's a whole lot of risk involved with moving forward with the bill as is.
Okay, noted. Is there any other discussion? Representative McKenzie.
I would just echo what what Representative Sullivan said. This is a bill to make sure that people who are out on workers' compensation understand what it is that they owe. And that was what I thought the whole focus of this bill was, so there'll be no surprises. And I'm not sure how that spun into the explanation I just heard, or the questions I heard from Representative Avaloni. But people have a right to know, and they don't want to go on workers' compensation, come back 6 or 8 and 9 months later and find out they owe $10,000 to their employers. And I think that's what you know, we were trying to focus on with this legislation. And I think if we were to kill it, it's you know, would not be the best thing for the employees. Just let them know. Thank you, Mr. Chairman.
I appreciate your comments, and I agree with your sentiment. Go ahead, Representative Granger, go ahead.
Would it be in order to call a caucus?
It's a valid motion.
I move to call a caucus, if that's the word for it.
All right. Republicans, let's go in the back room. And we'll recess for 10 minutes.
I'm in state vet, but it's, you know, we're done for a session. But science, technology, and energy, I'm a very well informed person.
Thank you, Mr. Chair. I think I am ready. I think I agree with my colleagues that it's a notification bill. And if we find that people are being notified with the information that they need, I think that would be the good outcome. And that if we find later, as often happens, that something else needs to be done, we could certainly revisit this in yet another term.
Okay, thank you. Are there any other comments? Seeing none, Mr. Clerk, can you please call the roll?
Representative Avalani,
Yes.
Representative Flanagan,
And I'm sorry, the motion is ITL on 169. Go ahead.
Representative Giason,
Yes.
Representative Warden,
Yes.
Representative Drago,
Yes.
Representative Granger. Aye. Representative Farrington.
Yes.
Representative Hall not here. The clerk is yes. Representative Labrie.
Yes.
Representative Sullivan.
No.
Representative Cahill.
No.
Representative Ryan.
No.
Representative Susie.
No.
Representative Foss.
No.
Representative McKenzie.
No.
Yeah, I got you. Thank you.
It's fine. He voted. He voted and it's on record. I'm okay with that.
Maybe we may go now. May I continue? Yeah.
Go ahead and continue.
Okay. Representative Schultz.
Have you voted yet? Did I miss that? I'm sorry, no.
Representative Leclerc.
No.
Representative Staub.
No.
And Chairman Creighton.
Yes.
7, 8, 9, 10, 10, and 9. 8, 9, 10, 9. Passes.
Okay, 10-9, the ITL motion passes. And again, on this bill, and I was going to say this before we recessed, is I think that in general, we agree with the intention of the bill. We're not comfortable with the wording. We want to give it back to the Senate to figure it out. And so my sense, what I will do is table this bill on the floor. So it goes back to the Senate and they can figure out that reading. Because I agree, people should be notified. But I think that the legislation should be more clearly defined on who is notified and how that works. With that, this bill, ITL 10-9, is going on the calendar. And closing the hearing on SB 169. And for the minority report on 169. Okay. And the majority report, you got it? All right, Representative Farrington. Okay, I'd like to open the session on SB 171 relative to required pay for remote work. Representative Labrie, do you have a motion?
A motion OTP.
The motion is OTP. Do I have a second?
Second.
Representative Avalani seconds. And would you like to speak to your motion?
I would. We're gonna put an amendment forward here in a minute. Everybody has a copy of it. That's what I have.
So you'd like to introduce
So
an
I'd like to-
amendment?
I can speak to that now if you'd like.
Would you speak to your amendment?
So the amendment here is to repeal RSA 275-43-A.
Okay.
Thank you.
All right. Continue. Representative Labrie, go ahead. All right.
Sir, if I could you motion to caucus?
That's a valid motion. I, yeah, let's caucus, 15 minutes. And we'll recess.
Anyone watching the Red Sox?
if I could have everyone's attention, um, I'd like to do the discussion on the subcommittee while we have a minute. And so we heard two bills this year that I personally thought were really close, but not there. And one of those was HB 744 relative to workers' compensation indemnity benefits percentage. Subcommittee up. The purpose of that subcommittee is to create legislation that achieves the intention of those two bills with less cost. And there is a way to do that. And if you work with the departments, they've got some ideas, and then we've got some ideas within this committee. And I thought that it was beyond what we were able to do with an amendment, but clearly within what we're able to do. And I would like to challenge Representative Avalani with legislation submitted in September that's a committee bill that does that we agree to. Is there any comments or discussion from anyone on that? There's thoughts on that?
I would agree that it's worth the effort to try to bring something together, especially something that we can do on a bipartisan basis. If we can do that, I'm all for it, and I will be willing to serve on that subcommittee.
Well, great. I appreciate that. And Representative Labrie, would you have time to help out on that?
Yes, happy to do it.
Okay. So Representative Avalani will chair that subcommittee with Representative Sullivan and Representative Labrie as co-members. And would you like to speak to your thoughts on that?
Love to, Mr. Chairman. Thank you, Mr. Chairman. I've had some discussions with Deputy Commissioner Lavers. We've also heard from NCCI and from providers and the insurance commissioners on the percentage on workman's comp. I think there is something that we can do on one of those. The other one, we just might need to have some more clarity on what and how we administer the 60% and as compared to other states, because I know that we are kind of an outlier in that the 60% of their full pay. So we're going to take a look at that. Also call in the players with that to make sure that we have employers, employees, and the Department of Labor and probably some other departments as well to make sure that we're on the right track. And for unemployment insurance, I think asking the Deputy Commissioner for a way forward is probably, I don't think anybody's ever done that. So I think that's a good way to start that conversation.
Okay, excellent. Go ahead.
And I know with the demographics being what they are in the committee, two from the majority, one from the minority is the way things generally stack up. However, with Representative McKenzie being the prime sponsor on both of these, I will be turning to him for guidance and assistance. So when the committee meets, I will make a point of making sure that Representative McKenzie can be with us. We only get one vote, but you get two heads.
No, that's awesome. It would be a better solution. Thank you. And Representative McKenzie, I hope you're okay with that. This is a full committee caucus. You never heard of that? Come on, I just got here. Okay, so the mission is pretty clear. September, two pieces of legislation that accomplish what we just discussed. Representative Cahill.
Thank you, Mr. Chair. If I may, in the spirit of making this purely bipartisan and taking advantage of the knowledge and experience of Representative McKenzie, I'd like to propose that the membership of the committee be four people, two from each party, all with their knowledge and experience to benefit the joint effort.
And I appreciate your suggestion.
Thank you.
Noted. Yes, ma'am. Representative Schultz.
Is
It's on the record.
Is it germane to this conversation to raise an additional potential bipartisan issue related to work we've had this year?
Absolutely, ma'am.
I hope this doesn't turn off the moment I say minimum wage, but here's the piece that I feel we can all agree on. If we could find a way to address the fact that there are working people that have to go on public assistance at places that pay workers so low, and those jobs tend to be women. They tend to have children at home under the age of 18, and the impact that has on all of us. It's essentially a backdoor welfare for companies and other employers. Is there a possibility we could look at that issue in some fashion and come up with a way to address that in a bipartisan way?
Ma'am, I appreciate, I would rather the subcommittee focus on the two bills that they've been given.
I didn't mean to hijack that committee. I just meant as a working group of some sort, since both of the minimum wage bills were tabled and could come back. It would be really, I don't know exactly what Republicans would think of it per se, but I do know anytime I've raised this issue of workers needing to go on public assistance because employers pay so low, I feel like that's a thing we almost completely agree on, that that's not the way working America should be, or working New Hampshire should be. I feel like that's the one area around the minimum wage we could agree on, or low wage issues in general. So putting that out there as a consideration.
I appreciate the thought, and if you can find folks that will work with you, I'm not willing to take that on as a committee project. But one thing that I am willing to, I'm sorry, go ahead.
I will say that I think a working group for that topic is entirely appropriate. And frankly, I'm committed to working on that until we get a minimum wage for the state of New Hampshire. So I'm on board with working on it. We will keep working on it. Thank you.
Great. Excellent. I would say that there's another bill out there that we're working on that the price tag is what gagged me, and the concern about OSHA standards. And I'm not willing to sign on to what was presented this year because I'm really skeptical on the cost. But I do recognize the numbers that were displayed that said that the injury rate among public employees was much greater than the injury rate among private employers. Representative Solom, do you want to talk about what you're doing and what I've committed to help you with?
Yeah, basically, we've had very good luck working with the Department of Labor on this topic. The amendment that we came up with last year that, in my opinion, went leaps and bounds towards having a more workable New Hampshire solution to the public sector safety standards. That came right out of the Department of Labor. That was their suggestion, and I was very pleased with where it took us. It became clear to me this year that we didn't have it in this committee to get it through, and rather than just having it die a sweet death, I made the motion to retain it. And essentially, I want to go back to the Department of Labor and see if they have any strategies to address some of the concerns that still exist around the bill. So I expect that the chairman and myself will be meeting with personnel from the Department of Labor to seek solutions and put them back to work and see what they can come up with.
Yes, sir.
Thank you, Mr. Chair. So one of the disparities here in terms of the public application versus the private application is that the government investigates and fines and takes OSHA standards out against private agencies. They don't self-investigate the same way or at the same rate. So the liability to the government to commit offenses against OSHA simply doesn't exist because the government is the investigator. So the private companies are always going to be more in compliance because they actually have something to lose.
Can I ask a
Except in New Hampshire, the public is not subject to OSHA. It's subject to Department of Labor, which is completely different set of rules.
Can I ask too, when you refer to the government, who are you talking? The state government, federal government, OSHA itself?
OSHA itself is more likely to investigate private entities than it is state projects.
It does. It actually goes all different ways. Some states at the time when OSHA came into being said, we're all in. We want OSHA to oversee safety standards for all employees in the state, public and private. Others said, we know we're obligated to have the public and private sector employees covered by OSHA. We're going to hold the public sector out. And since then, some of these states that held out early on have adopted a state plan for OSHA. That state plan is administered by the state, but it's a joint effort between OSHA and the state labor department or whatever department oversees safety. And so they use the OSHA standards. The department does the investigations, the State Department, and so it's sort of a hybrid type thing. What the amendment that we came up with last year did is rather than adopting the OSHA standards straight away, we made a commitment to write rules through the Department of Labor that would be at least as effective as the OSHA safety standards. And what it did is it gave the department some flexibility to write the rules in a more readable, usable way. It allows the department to interpret those rules in a common sense kind of way, so that if it isn't exactly OSHA, but it's at least as effective, it still passes. So I think we came up with something that is not a state plan, but it's not nearly as rigid as a state plan would be. And so I really believe it's something that's workable. And we just need to figure out how to get from the implementation of it, or through the implementation of it, so that all the public sector employers can be able to work within it. But I think the core is there. We just need to address the issues that the chair has raised. Thank you for tolerating my soliloquy.
Not at all, no problem. No, my entire point was Henry's Tractors is going to get fined, is going to get closed, is going to file for bankruptcy. The state of New Hampshire is not going to take the same penalties out on the DOT. So there's a disparity as to how the law is applied. That was my point. I agree with increasing the safety standards. I generally disagree with rules writing authority because it's not legislative, but I think that you are moving in the right direction, sir.
Representative Granger.
Thank you, Mr. Chair. This country used to do really, really great things, and we don't build giant bridges anymore. We don't build skyscrapers. We don't do as many wonderful things as we used to. And the difference between the technology we had in the 1930s that enabled us to do these things and the technology we have now, we didn't go backwards in time. We still could do all this stuff, but something's holding us back. And I think that we ended up in our culture, and this became especially obvious in 2020, we ended up worshiping safety, because I think a lot of people think that this is the only life you have and you don't have anywhere to go after this. So therefore, if that's the case, then your priorities become a little bit different. You don't worry about accomplishing great works. You don't worry about building a giant cathedral. You don't worry about any of that stuff. You worry about not dying as the first and foremost things. But death is not the worst of evils, I should say. And I think that while well-intentioned, OSHA has overstayed its use, and we should probably get rid of it. We can't do it at the state level. But I would just like to throw in and say we should just not have OSHA anymore. Thank you. I would die for that bridge.
Representative McKenzie.
If we have a minute.
We have a minute for you, the world.
So there's no doubt, looking at the evidence and the long history of OSHA, that it has saved the lives of thousands of people in the United States of America. That workplaces are safer, that people are better off and they get to go home at the end of the day. And while you may not notice the impact of OSHA, if you go around with a safety inspector and you look at the buildings, you can see the evidence of what OSHA, the difference that OSHA has made. The way they protect workers today, the way they harness people in, the way they deal with roofs and steel buildings and all those other kinds of things, none of that existed prior to the passage of OSHA. And OSHA has been a game changer in the safety and health, and it has saved people's lives, and it has saved millions of dollars in workers' compensation costs as a result of that. And more importantly, it has saved people the misery of losing somebody to an industrial accident. And that has been the benefit of OSHA. So when we say we don't need it, what's the solution? Everybody kind of go out on their own, and you're gonna see this whole situation go down the drain.
Yeah,
That's my opinion. If we had a minute. to
I've
talk,
spent, no, it's fair enough. It's a fair statement. I've spent 10 years of my life in places that most people probably haven't been without OSHA. And if I could show you all the pictures of, for example, I was in the Balkans, and I've got this picture of the way they do wiring in the Balkans. And the way they do it is that the government has a wire, and that wire sort of meanders through the middle of town. And then each house, each person goes up and shimmies up that pole. And then they attach, I don't know how they do it, but they attach their line to this pole. So you see these poles in the middle of town with hundreds of sub things going off. OSHA would have a field day with that. But, no, yeah, I mean it's standard. But in my first exposure to that was in Kosovo. But on the other hand, just bear with me because we're waiting for Mr. Gimpy to come. So I'm in Afghanistan, and there's this police station that they're building. And I get there, and it's only 60% complete. And so I said, well, why is it only 60% complete? And there was this whole craziness about the way we're spending money, which was absolutely wrong. But we finally got it back on track. It took 6 months. So we get it back on track, and then they stop working. I said, why do you stop working? Well, because the United States Corps of Engineers had to follow OSHA standards. And the stairs weren't exactly constructed to OSHA standards. So here we are in Afghanistan, where I don't know if OSHA still applies in Afghanistan, but we were following these rules that, it didn't make a whole lot of sense to me. But anyway. Yeah. Anyway. I know. I know. I appreciate your diligence, Representative Flanagan. And I will take us out of recess on Senate Bill 171. And to review the bidding, we have a motion of ought to pass and with amendment. And Representative Labrie, would you like to present your amendment?
Yep, so I do have an amendment here. You should all have a copy of it in front of you. This amendment repeals RSA 275-43 in its entirety and removes the 2-hour minimum.
Is there a second on the amendment? Representative Granger seconds the amendment.
I second the amendment.
And would you like to speak to your amendment?
Briefly. Thank you, Mr. Chair. It's been discussed for an hour, and I can tell you that this, in my opinion, this particular bill has been hijacked, compartmentalized, it's confusing, it's unenforceable, it's discriminatory, and it's going to get worse before it gets better. I would say let's let these businesses set policy and trust our employees and the businesses to come to agreements that work for both parties.
Is there any other discussion? Would you like to speak to your second?
Thank you, Mr. Chair. I would agree with that. I believe that the current law is kind of a micromanaging sort of piece of law. Most states don't do it this way, and we don't. It's not really the live free or die spirit that we kind of like to maintain here.
Is there anyone else? Representative McKenzie.
Thank you, Mr. Chairman. I'm probably the only one that was in the room when this was passed. And where it came from was the chair of the House Labor Committee worked for a bank. And the bank would call him up and he would go down to the bank 15 minutes to reset the alarm. And so he decided, you know, he put a bill in to basically say it would require 2 hours. That's where this thing came from initially. Now, during the course of the years, this has worked for the most part. The problem we're running into now is that we are introducing into the environment an entirely different structure of work. And so, and I understand that we're changing, we need to adapt to that. But to wholesale just take pieces out of the law, as we've done some other legislation here, is short-sighted. And what I would hope we would do is to take the time and look at some of this legislation and look how it is that when you hit this cue ball, when you hit that thing, where these balls end up. And I don't think this gives us the time to do that. It doesn't look at the history of this legislation. It doesn't look at the impact that this is going to have when this gets removed. And when we passed this thing, it took us days, if not weeks, to get the law into the thing. And we're going to take this out in half an hour. I think that's an injustice to the people that are going to be affected by this. So what we're going to tell people is that the employee can call you back. You got to go back. You're not going to get paid if you go back. You're just going to end up, so that's all gone. That's all gone. And so we shifted over, so employers are going to take care of the employees. Let me tell you, my business, employees don't always take care of employees. And I think we leave this in until we get to the point where at least we can figure out what happens with this. When we start taking whole sections of the labor law that have been in place for many, many years and start the process of looking at remote work in a comprehensive way to address remote work and the implications that has for the workplaces. That's my concern. And I'm willing to work on that. I've introduced legislation about that, about remote work. What does it mean? But this is not the time to start pulling wholesale sections out of the law. So I would oppose the amendment, Mr. Chairman.
Okay, I appreciate your comments. Any other questions? Representative Sullivan.
I think this is a classic example of throwing out the baby with the bathwater. Essentially, we started trying to fix one small piece of the workforce, and now we're completely undoing a piece of protection that's been in place for a long time. I mean, there's a reason why this law is here, because people have been abused. People have been asked to come in, perhaps not knowing if they were needed or not, and once they got in, they got sent home. And they wasted perhaps half a day in the process of getting zero pay. So the underlying statute serves an important purpose. I believe the bill itself, which we're not discussing at the moment, but I'll just say I can support because I understand the flexibility of working from home. I did it for 14 years. I will not support the amendment. I think it's a step way too far, and it is not where we began with this process. This completely hijacks a bill with an entirely different purpose. Thank you.
Okay, any other comments? Yes, ma'am.
Just speaking as an employee at many a workplace who was fortunate enough to have this rule in place, it just strikes me as strange that the employee is penalized for, whatever mileage they had to use, whatever time out of their day they had to use, whatever childcare they might have had to set up. And that's, not necessarily. When I worked in Manchester, I had a coworker who worked in Henniker. And if she came in because they thought that they needed her and then it was, okay, no, actually, we have to send you back. It's a issue with the business's scheduling and their foresight that the employee is being penalized for and has to spend money for. So I know I wasn't here when you all discussed this. Maybe that did come up, but it's just my perspective as somebody who has worked at, many a place where this rule is in place.
Thank you. All right, any substance, any other questions? Can you call a roll on the amendment?
Representative Avalani,
Yes.
Representative Flanagan, Representative Giason,
Yes.
Representative Warden,
Yes.
Representative Drago,
Yes.
Representative Granger.
Aye.
Representative Farrington.
Yes.
Hall's not here. The clerk is yes. Representative Labrie.
Yes.
Representative Sullivan.
No.
Representative Cahill.
No.
Representative Ryan.
No.
Representative Susie.
No.
Representative Foss.
No.
Representative McKenzie. Representative Schultz.
No.
Representative Leclerc.
Nope.
Representative Staub.
No.
Chairman Creighton.
Yes.
10-9. Or, yeah, 10-9.
All right, so the motion, is there a motion, Mr. Representative Labry?
Motion 171 OTP.
OTPA.
OTPA, sorry.
Is there a second?
Second, Mr. Chairman.
Mr. Representative Avalani seconds. Is there any further discussion? Seeing no further discussion, can you call the roll?
Representative Avalani.
Yes.
Representative Flanagan.
Yes.
Representative Giason.
Yes.
Representative Warden.
Yes.
Representative Drago.
Yes.
Representative Granger.
Aye.
Representative Farrington.
Yes.
Representative Hall's not here. Clerk is yes. Representative Labrie.
Yes.
Representative Sullivan.
Yes.
Representative Cahill.
No.
Representative Ryan.
No.
Representative Susie.
No.
Representative Foss.
No.
Representative McKenzie.
No.
Representative Schultz.
No.
Representative Leclerc.
No.
Representative Staub.
No.
Chairman Creighton.
Yes.
11-8.
All right, and for the majority report, Representative Labry?
Yep.
And for the minority report?
Yep.
Representative McKenzie, you got the minority report?
And I'll do the other memorial.
You're gonna do 169?
Yep.
Okay, and, Mr. Deputy, can we review the minority and majority report? Who's doing them?
Certainly, Mr. Chairman. Representative Kessler.
Hey, guys, if we could just have one person speaking, please, including everyone. Okay, thank you.
Thank you, Mr. Chairman. Rep. Kesseling has the OTP on 28. I have the OTP ITL on 67. Representative Farrington has the ITL on 169. Representative Sullivan has the minority report. SB 171 OTPA, Representative Labrie, with Representative McKenzie doing the minority report.
Okay. And you're doing the, oh, I was just gonna say, if we can get them in by noon tomorrow. That way they get into the calendar. They're due, in order to get into the calendar, you have to have them in by noon tomorrow. So if you can send those, I think you send, are you gonna take those, Representative Sullivan, or? Okay, so you get it to Representative Sullivan, he'll get it to me, we'll get it in, okay? All right, so this closes the executive session. And it also, we finished the subcommittee work, so thank you for that. I appreciate everyone stepping up for that. This will be the last session of this first year. And I'll just say, from my perspective, having come in here with an immense amount of labor experience and it really just, it's been a thrill for me to be here this year. I'm looking forward to next year. And, I'm hoping that we get some things done next year. And I appreciate everyone's candor, everyone's respect. And I think that those things that we agreed to on day one, we lived up to. And, hopefully we can get some more things done next year. So with that, this session's adjourned. Thank you.